Your Honors, good afternoon. This is a continuation of the oral arguments for the 37 consolidated petitions assailing Republic Act 11479, the Anti-Terrorism Act of 2020. Appearances? May I request the representing counsels to please make your appearances.
Good afternoon, Your Honors, Mr. Chief Justice. Attorney Jose Anselmo I. Cadiz, for Petitioner, Integrated Bar of the Philippines, and the governors of the Integrated Bar of the Philippines in GR 253624, Your Honor. Thank you very much.
Respectfully appearing as counsel for petitioners in GR 252741, Attorney Jose Manuel Diokno. Ready, Your Honors.
Good afternoon, Your Honors. Respectfully appearing for petitioners, Justice Antonio T. Carpio, Justice Conchita Carpio Morales, UP Law professors in GR number 252736, Your Honor. I am Alfredo B. Molo III, Your Honors. We are ready.
Good afternoon, Your Honors. Evelyn Ursua, respectfully appearing for the petitioners in GR number 252747 and UJP et al., Your Honors.
Good afternoon, Your Honors. Edsel Tagman, same appearance for the petitioners in GR number 252579.
Good afternoon po, Your Honors. Respectfully appearing for petitioners of 252585, Your Honors, please. Nery Colmenares po.
Assalamualaikum, Your Honors. Appearing for GR number 252759, I'm Attorney Algamar Latif, Your Honor. We are ready, Your Honor.
For the respondent.
Test, 1, 2, 3, test. Good afternoon, Your Honors. Chief Justice Diosdado M. Peralta, Honorable Justices of the Court, good afternoon. Appearing as counsel for the respondents, Your Honors, are the following. Assistant Solicitor General Marisa de la Cruz Galandines, ASG Rex Bernardo L. Pascual, ASG Raymond I. Rigodon, State Solicitor Eduardo Pokis Jr., Associate Solicitor Kyle Brian Guerrero, and the Solicitor General, Your Honors. Your Honors, there is a supervening event after the conclusion of the oral arguments last February 2, 2021. This will affect not only the continuance of the oral argument, but the resolution of the pending petitions as well. Hence, I beg leave to be heard on an urgent oral manifestation, Your Honors.
Okay, go ahead, Mr. Solicitor General.
Thank you, Your Honor. I am submitting to the Clerk of Court and back 3 video clips.
I am submitting to the Clerk of Court and Bank 3 video clips, and now I'm showing before you the first of the 3. 15 copies of the transcript and the affidavits authenticating the video are submitted herewith to the Clerk of Court.
May I interrupt you for a while, Mr. Solicitor General? Because you just have given us this document. Can you just summarize what you want to manifest for economy purposes?
The video clip and accompanying affidavits, which were subscribed before the PAO, were attached to the endorsement to the Office of the Solicitor General, duly signed by Provincial Legal Officer of the National Commission on Indigenous Peoples, or NCIP, in Zambales. The NCIP and PAO are reportedly the new counsel of Gurong and Ramos, the two ETAs, Your Honors. In addition to the video clip, Gurong and Ramos executed a pinagsamang salaysay ng pag-uurong, stating as follows. In number 2, ayaw po naming pirmahan ang mga dokumento referring to the petition in intervention. Napilitan na rin kaming pumirma. Binigyan po kami ng 1,000 at hatiin daw po namin. In number 5 of that salaysay says, sinabihan pa nga ako na di ka ba naawa sa abogada? Galing pa siya sa Manila para papirmahin ka lang. Unquote. In paragraph 6, it says, nakiusap din ako na sana lubayan niyo ang magulang ko. Number 11, aming inuurong ang petition and intervention na aming napirmahan sa kadahilanang hindi bukal sa aming puso at kapasyahan ang pagpirma. It may be recalled that during the last hearing, the Honorable Justice Leonen asked whether the court should wait for an actual case before it weighs in on the constitutionality of the law. The Honorable Justice even hinted that maybe the ETA case could provide an actual controversy to warrant this Honorable Court's exercise of its power of judicial review. Mindful of this predicament beforehand, and in a desperate attempt to establish actual justiciable controversy in these consolidated petitions, the NUPL, representing Bagong Alyansang Makabayan, in GR number 252733, Barangay Maglaking, San Carlos City, Pangasinan, Sangguniang Kabataan in GR number 252921, and Coordinating Council for the People's Development and Governance in GR number 253242, filed before this honorable court a motion for leave to file petition in intervention for Gurong and Ramos. Gurong and Ramos are presently facing criminal charges for violations of the Anti-Terrorism Act before the Regional Trial Court in Olongapo. It must be remembered that in Abogado et al. Versus DENR et al., our fisher folks from Palawan and Zambales who were victims of deception disowned the petitions filed in their behalf for the issuance of writs of kalikasan and continuing mandamus over the Panatag Shoal, Panganiban Reef, and Ayungin Shoal. In said case, this honorable court sternly warned the councils to be mindful of their duties and obligations under the Code of Professional Responsibility, and that the same or similar infractions in the future shall be dealt with more severely.
Excuse me, Mr. Solicitor General. Will you allow me to interrupt you? The petition for intervention filed by the would-be intervenors has been unanimously denied by us this morning. So is there still a need for you to read all of those documents because we have already denied the petition for intervention? Now, if you want to push through with what you want to manifest to us or what to move to us this afternoon, I believe that you put that in writing so that the other party can comment on that later on, so that we can already proceed with our oral arguments this afternoon.
Yes,
okay. So, yes, Congressman Colmenares.
Hello. Thank you, Your Honor. I'd just like to react about this latest development alleging that lawyers of NUPL were forced the intervenors, Your Honors. In the first place, Your Honor, we are not aware of this latest development, but it is really strange why lawyers can force a detainee inside a PNP camp. That's really outrageous, Your Honors. And secondly, we would like to inquire from lawyers who signed who were counsels to the intervention, whether when the respondents talked to the petitioners, was their counsel also at the time, Your Honor? Because it seems that we are really unaware of this. So the court has said that the intervention has been denied. However, we would like to, if the manifestation is filed by the Solicitor General, Your Honor, we would like to respond to that, Your Honor, in proper time, Your Honor.
Let us wait for their motion. Okay.
Thank you,
Anyway, it is only a manifestation, so there is no yet motion.
Thank
so
you,
if they want to pursue through a motion, then let us wait for the motion. If there is none, then you can sleep well.
Thank you.
Okay. So let's now proceed with the oral arguments. Justice Marvick Lonin can continue with the interpellation.
Is Attorney Latif here in the session hall?
Yeah. Good afternoon, Your Honors.
Assalamualaikum.
Salam, Your Honors.
I am sorry that during your opening statement, you mentioned that there was still this discrimination against the Muslim population in this country, and that there seems to be an impression according to your opening statement, that most of the terrorist acts come from Muslim Filipinos. Am I correct in hearing your opening statement?
That is correct, Your Honor.
Yes. And but then on the other hand, you are aware that there have been terrorist incidents in many places in Mindanao as well as in the environs of Metro Manila.
Yes, that is correct, Your Honor.
For example, on February 27, 2004, this was the Super Ferry incident. You remember this? Where there were 116 people that were killed due to a bomb that was hidden in a television that was loaded into Super Ferry number 14. Out of the 116 people, 6 children less than 5 years old, 9 children between 6 and 16, and 6 students sent from northern Mindanao to a journalism competition were killed. You're aware of this?
Yes, in general, Your Honor, I'm aware.
And would you recall who the perpetrators were as found by our Philippine National Police and our ISAP?
I am not aware of the identity.
You've heard of the Raha Sulaiman movement, correct?
Yes, I recall,
Yes,
Your Honor.
they are of a different kind of jurisprudence in Islam. I believe Salafi jihadists. And do you know who trained them?
I do not know, Your Honor.
Abu Sayyaf and Jamaya Islamiyah.
I am not aware.
Particularly the Jamaya Islamiyah with links to Al-Qaeda in 2004.
I am not aware.
Yes. And you know where Jamaya Islamiyah comes from?
I recall, Your Honor, that they're from Indonesia, Your Honor.
Most of them are in Indonesia. And our links with the Philippines, according to intelligence reports, at least when I was working with the executive branch, and I believe that at a certain point, our national security advisor, I believe, is he here? General Esperon, is he here? Or no? But at a certain point, maybe our national security advisor or perhaps the Solicitor General can share with us that there are indeed, shall we say, transits of several high-value targets or terrorists wanted internationally through our backdoor, specifically Mindanao. You understand that?
Yes, Your Honor, I'm aware of that, Your Honor.
Yes. And 116 people means there are 116 families. 6 children less than 5 years old in 2004, 9 children between 6 and 16-year-old, 6 students from northern Mindanao for a journalism contest. You agree with me that this was a terrorist act?
Yes, I agree with you, Your Honor.
Yes, this was in 2004. I can go through the incidents in 2017. So in Basilan, kidnapping and execution, July 5. Basilan, July 30, kidnapping, execution, 7 Filipino loggers were beheaded in 2 separate towns in Basilan. August 5, Mindanao, 5 MILF guerrillas killed in a landmine blast while running after BIFF militants in the area. August 21, 2017, Maluso, Basilan. August 29, in Sulu, 3 people of the Muslim clan were killed in a battle with the Abu Sayyaf group. July 31, 2018, bombing in Lamitan City. August 28, in Isulan, Soc-Sargen, bombing. Also September 2. January 27, 2019, Holo, Sulu, a cathedral bombing. 20 people were killed, 82 others wounded during the mass at Holo Cathedral following 2 explosions. This was the Jama'a Ansharut Daula group. Particularly Ruli Rian Zike and Ulfa Handayani Saleh with the Abu Sayyaf Ajang faction. And then, of course, the latest in my record is the August 24, 20 Holo bombing, where jihadists detonated 2 bombs, killing 14 people, wounding 17 others. The first bomb was detonated while the army was carrying out COVID humanitarian efforts. And the second bomb was exploded inside the Our Lady of Mount Carmel Cathedral. You are familiar that these incidents do happen within our territory.
Yes, Your Honor, I'm aware of that, Your Honor.
And you are aware, therefore, that terrorism is really something which is very real, correct?
Yes, it is real, Your Honor.
Yes, so it is not only something that is against, let us say, the CPP, NPA, NDF, but there are a lot of other groups coming to our shores, whether alleged jihadists, because I know that in Islam, jihad can mean so many things. And there is really correct interpretation of jihad in the Quran, not what is carried by the Salafi. Am I correct?
Yes, Your Honor. Jihad, Your Honor, means, Your Honor, self-struggle, Your Honor. And it collectively, Your Honor, it is equivalent in our jurisprudence, Your Honor, is self-preservation, Your Honor.
And not only religious extremists that become violent and therefore do terrorist acts, but there are, let us say, rightist groups all over the world, correct?
Yes, Your Honor.
Yes.
That is
So
correct.
this concept of terrorism is very real. Is that not correct?
That is correct, Your Honor.
Yes. And therefore, would you agree with me that it is right for government to find a way to address terrorism?
Yes, we totally agree with the government, Your Honor.
Yes. And let me make an analogy. Before a car crashes, before a speeding car crashes into a wall or killing several pedestrians, there is a law which regulates speeding. Is that not correct?
Yes, Your Honor.
And therefore, even before the harm is done, it is important that for certain kinds of acts, government looks at prevention or suppression of particular acts before they happen. Is that not correct?
Yes, Your Honor, that's correct.
Would you not think that terrorism is a kind of act, regardless of how it is defined now, but the general concept of terrorism, and I think you and I know, the Lamitan incident, Super Ferry incident, the Holo bombing, the Holo Cathedral bombing, these are the core concepts of terrorism. That we should not wait until it happens, that we should give our law enforcers, whether it's the PNP or the ISAP or whatever intelligence agency that we have, the tools in order to be able to detect. And more importantly, not only to detect and prosecute, but to actually disperse or disturb the actual incident. Is that not correct?
That is correct, Your Honor.
And a committed terrorist, whether a rightist, a leftist, a religious extremist, or even an environmental anarchist, all of them, when they are committed, of course, while the act is doing and while they have co-conspirators, it is important that we cut the means of communication with each other so that the entire incident is disrupted. Isn't that correct?
Yes, correct, Your Honor.
So there is a criminal part of it, which is to prosecute and convict in order that it becomes a deterrent and to prevent for the future. But in terms of addressing terrorism, there is also the law enforcement part to try to suppress so that it will not happen. Is that not correct?
Yes, Your Honor, that is correct.
Yes. And as a matter of fact, under international law, there have been two basic approaches to attending to terrorist acts. The first approach is, of course, considering it as a threat to international peace. Is that not correct?
Yes, Your Honor.
And as a threat to international peace, of course, it's the Security Council that is involved. And normally, therefore, it is the executive part, the commanders-in-chief of various agencies that can do preemptive acts, like the United States doing a preventive act against Al-Qaeda or the ISIS, etc., or to address it as part of armed conflict. Is that not correct?
That is correct, Your
And
Honor.
that is true for, let us say, the Abu Sayyaf, certain parts of it, and of course, what is now called as the Bangsamoro Islamic Freedom Fighters, somewhere in Maguindanao and its environs. Is that not correct?
Yes, that is correct,
Yes.
Your Honor.
But there is also the other part, which is for criminalizing these acts. And therefore, for the criminalization of these acts, the proper laws must be promulgated and the acts must be stated. Is that not correct?
Yes, that is correct.
What happens if the Philippines does not have a law that is against terrorism?
We may be sanctioned, Your Honor, by the United Nations
Security Council. I'm
Your
glad
Honor.
you said that because I did hear one of the councils, I think it was Attorney Ging Ursua during the past, saying that there are no sanctions coming from the Security Council. But I'm glad you said that. I do not have to show to you the provisions in Chapter 7 of the UN Charter that indeed the Security Council may sanction any state party to the UN Charter if they do not follow their bidding or their requirements. Okay, so we have these types of types of obligations. Apart from that, apart from the sanctions, what can happen to us if we do not have and we do not participate in the international effort to prevent, suppress, and criminalize and address terrorism?
We may be isolated from the international world, Your Honor.
Not only that, do you think that we will become a safe haven?
That is correct, Your Honor.
Yes, because they will not be able to go to our neighboring countries like Malaysia, they have very strict rules, or Singapore, or even Indonesia for that matter. Then they will actually use the hinterlands or our places in Mindanao, correct?
That is correct.
Yes, and as a matter of fact, I'm not sure if you are aware that Marwan was located in Mindanao, correct?
Yes, that is correct, Your
Yes,
Honor.
he was the object of the Mama Sapano incident, correct?
Yes, that is
And
correct.
you are also aware that many of the international high-value targets will go to Mindanao, marry a Filipina, usually from one of the communities, to get protection with them. Is that not correct?
Yes, that is the
Yes.
case of Marwan.
So
Your
the
Honor.
concept of us becoming a safe haven might be actually happening even as we speak. Is that not correct?
That is correct, Your Honor.
Yes. If therefore we do not comply with international law or what is called by the Security Council in terms of preventing, suppressing, and attending to terrorism, that we will become the pariah because we will be training the bombers that will go to Malaysia, to Indonesia, to Hong Kong, to the United States of America, as probably we had some connection with the 9/11 incident. Is that not correct?
That is correct, Your Honor.
Yes. So therefore, it is important that our laws are not only backward, not only rudimentary, but they must be state-of-the-art in order to equip our law enforcers with respect to attending to terrorism. Is that not correct?
Yes, Your Honor. I agree.
And would you say that this court, in assessing the constitutionality of the provisions, must also take that into consideration, not only our domestic parochial concerns, but also the reality that terrorism is an international phenomenon. As a matter of fact, social media can create epistemic bubbles. Is that not correct?
That is correct, Your
Yes,
Honor.
and that is the way that many of our disenchanted youth may be radicalized using that particular medium. Is that not correct?
That is correct, Your Honor.
And would you agree with me that, as a matter of fact, there have been reports by our intelligence agencies, and perhaps again the Solicitor General can present the reports at some point, that in Syria, in Afghanistan, there were Filipino militants who made their way to those places as part of Mujahideen during the time that they were trying to repel the Russian forces, and then as a follow-on, going to Syria and going to places where ISIS was present. Is that not correct?
Based on my reading on the newspaper, Your Honor.
It's possible, correct? Yes, and the truth is, of course, even the Marawi incident has international connections. Isn't that correct?
I am not aware, Your Honor.
Yes. So would you agree with me that when this court assesses what the Congress did, we have to take into consideration the kind of standard required under the UN Security Council resolutions, as well as the ability of our country's law enforcers and intelligence agencies to be able to cooperate with other intelligence agencies, because terrorism knows no borders. Is that not correct?
Compliance with international body like the United Nations Security Council, Your Honor, it must comply with our Constitution,
Yes.
Your Honor.
And we have to do this not because we want to discriminate against the Moro or the Muslim. Okay, and Moro and Muslim are two different things. You agree with me, Attorney Latif?
Yes, I agree with you, Your
Yes.
Honor.
Moro has something to do with ethnicity to a particular locality. Bangsamoro, for instance, in Mindanao, Muslim is a adherence to a religion, and one of us can be Muslim here, although not Moro. Is that not correct?
That is correct, Your Honor.
Yes, and therefore, the reason that we also do this is not merely to discriminate against the Moro or the Muslim, but to protect. Because most of the bombs that I have surveyed from 2004 to 2020 have happened in Mindanao, although there were, of course, other incidents of my personal knowledge, having dealt with the security cluster in an administration past, where there were actually successful interventions done by law enforcers to prevent actual terrorist acts. Would you agree with me?
I cannot agree with you, Your Honor, because in
Because
terms
you
of
have no
law
knowledge.
enforcement, Your Honor.
Yes. And would you agree with me that in certain instances where they were able to interdict at that time They told me, intelligence agencies told me, that they did whatever they needed to do, despite the fact that the law was not yet the kind of law that we had, in order to be able to prevent a bombing, let us say, in a fiesta in Laguna and Quezon, or the Quiapo, what do you call this? Translation. You do not know, of course.
Yeah,
Yes,
aware
but
of that.
the truth is that, would you agree with me that we cannot stereotype all our intelligence agencies and all our intelligence personnel as people who want to violate human rights? But would you agree with me that there are people within that organization, the Army, the ISAP, the NICA, the NSA, that really fervently want to try to stop this kind of incidents from happening ever again? Is that not correct?
That is correct, Your Honor. But
Yes,
it
and you
is-
know, of course, that they are on a 24/7 watch basis. That they do not know which civilian, from where, etc., that this next attack will be coming from.
Yes, Your Honor.
Yes. So, in other words, that a terrorism law is essential, correct?
In the case of Marawi, Your Honor, it is not essential because there were those...
No, in general, a terrorism law is essential.
Yes, Your Honor.
An
it is
anti-terrorism law is essential.
essential. Yes, Your Honor. that
Yes,
is
and we must take care that when we rule upon the provisions of this law or this act, that the law enforcers are not left with nothing in terms of being able to address this horror of modern society. Is that not correct?
Yes, Your Honor.
Okay, let's just go to a definition of terms only for purposes of this interpellation. Extremism is different from terrorism. Would you agree with me?
Yes, Your Honor.
Yes, extremism is a belief. Terrorism is the method. Would you agree with me?
The method, Your Honor, is violence.
Yes,
based on my reading.
terrorism,
Yes, Your
which
Honor.
is a form of violence,
Yes, Your Honor.
writ large, in
Yes.
order to sow fear and compulsion and intimidation
That is
in
correct,
Section
Your
4, correct?
Yes, Your Honor.
So extremism can mean, for example, that I'm a Marxist. It means that the normative, being liberalism, maybe among the 15 justices here, maybe liberal, left of center, right of center, whatever. But when I am a Marxist, within the normative framework, I am an extremist. Is that not correct?
It can be, Your Honor.
If I am a Marxist, correct?
Yes, Your Honor.
And even if I'm a Marxist, there are many shades of Marxism. Would you agree with me?
Yes, Your Honor.
There is Marxist-Leninist, correct?
Yes, and
There's-
Maoist, Your Honor.
Yes, Marxist-Leninist, Maoist, correct?
Yes, Your Honor.
Can you point to a Marxist-Leninist, Maoist in the session hall? No, I'm just kidding.
No, I cannot do that.
But those are belief systems, correct?
Yes, it is confined with the realm
Yes.
of thought, Your Honor.
Yes, and there are Marxists which are later-day Marxists. There's the young Marx, there's the mature Marx. And there are Marxists from the critical school in Frankfurt, Marcuse, Althusser, Adorno, etc. These are also Marxists, correct?
I'm not aware of
Yes,
that.
and there are also feminist Marxists, correct? Angela Davis, etc. Right?
Yes,
Okay.
Your Honor.
So therefore, a belief in this system is not terrorism, correct?
Yes, Your Honor.
We
that is
have
the
to be
method.
clear about that,
Yes,
right?
Your Honor.
There is even a brand of Islam that hews closely to Marxism. Is that not true? The same way that in Islam, there are various schools of thought. You agree with me?
Yes, that is correct.
Yes, and there is the Sunni Shiite, there
Shiite.
is the Maliki, there is the etc. Many schools, correct?
That is correct, Your
Yes, there's even the romantic Sufism, correct?
Honor. Yes, Sufism, Your
And
Honor.
are you a Sufist?
No, Your Honor.
No, but like Rumi, etc. The beautiful poems of Rumi, going to tantric methods, etc. But the point there is there are various shades of various beliefs, correct? So extremism is different from terrorism. Is that not correct?
Yes, the one is...
As a matter of fact, part of the reason why the UN General Assembly hesitated to come out with a resolution prior to 49/60 in 1994 was because certain third world countries said that the freedom fighter is not a terrorist. You agree with me?
Yes, Your Honor.
But in that resolution in 1994, they separated. Whatever terrorist act you do, you cannot justify. You can never justify by means of an ideology or a philosophy. Is that not correct?
That is correct, Your
So
Honor.
we punish the method, but not the ideology, correct?
Yes.
So let me be very clear with you. You agree with me that this court should say that extremism should never be punished. Is that not correct?
Yes, Your Honor, because that is within the realm of thought. Then it is
Whether
an
you're
abstract.
rightist, you're the most rightist person in the world, you believe in fascism and totalitarianism, rightist method, or the most leftist, but you believe also in leftist totalitarianism, the vanguard party, the proletariat as the vanguard party, the dictatorship of the proletariat. Whatever your belief is, that should not be punished. Is that not correct?
Yes, Your Honor.
It's even covered in an international convention, correct?
Yes, Your Honor.
It's Article 19 of the International Convention on Civil and Political Rights, paragraph A. Is that not correct?
Yes, freedom of thought, Your Honor.
And freedom of opinion and embedded in this country. So when General Parlades says his point that he is offended by the statements made by the communists, that speech is also protected, correct?
It is protected, Your Honor, but he is accountable because he's an official of the military, Your Honor.
Yes. Will you prosecute that kind of speech?
Yes, Your Honor.
You will prosecute that kind of speech, but you will not prosecute the kind of speech saying that we should destabilize government in order to be able to rebuild. As Vladimir Ilyich Lenin said, a new society can only be had under the womb of an old one, correct?
That is correct.
By the
Your
way,
Honor.
did I commit a terrorist act by stating the statement or paraphrasing Vladimir Ilyich Lenin, who, by the way, is not my relative? Correct? But I did not, correct?
Yes, Your Honor.
I only made a statement of belief or faith or even a philosophy or a political point of view, correct?
That is
That
correct,
should
Your
not be punished. So we should make that distinction, correct?
That is
So
correct,
let me
Your Honor.
summarize. You agree with me that this court should take care that there is an anti-terrorism law that stands because it is part of our international obligation. That as a matter of fact, we should balance the way we read the Constitution in such a way that we comply also with our international commitments without, of course, undermining the basic values and principles contained in the Constitution. Is that not correct?
We already complied with, Your Honor, with the human security enactment of the human security law, Your Honor.
Your opinion. But
Yes,
again,
Your
as
Honor.
I was saying, this court must take that as a principle in terms of interpreting this new law, correct?
Yes, as long as it will not infringe the
Because,
Constitution.
of course, you agree with me, we cannot tell Congress and the Senate, you made a mistake. You should have just stuck with the old law, correct? That's a
Yes.
matter of policy, correct?
Thank you, Your Honor.
Our
Yes, Your Honor.
only justification for saying you should go back to the old law is when we find that the repealing clause is also null and void, and that we find a reason under the Constitution. Is that not correct?
That is correct.
We
Your
cannot
Honor.
substitute our judgment, right?
That is correct.
Yes.
Your
By the way, do you know any of us as having been able to implement or interdict a terrorist?
Honor. I have no knowledge of
We
that,
are,
Your Honor.
none of us are law enforcers, except I think our newest justice was a prosecutor, but that's not law enforcement. Is that not correct?
Yes, Your Honor.
I think also Justice Salameda was a prosecutor. One of the best prosecutors this country has produced, Justice Jolo,
Lopez.
Justice Rodil Salameda. Oh, and of course, if I'm not mistaken, the Chief Justice, whose judge was the strictest also in this world, Justice Romy Calleja, who is now our JIB. But none of us have ever been law enforcers. Is that not correct?
That is correct, Your Honor.
And we have no basis to say that the old law was less effective or more effective to interdict terrorists than the present law. Is that not correct?
That is your job, Your Honor, as the magistrate to interpret the law.
Yes, but we cannot say which one is the more effective to the intelligence component, the army, the police, the Navy has their own intelligence component, etc., because none of us have ever been there. Is that not correct?
Yes, Your Honor, because
We have to rely on manifestations and evidence that is presented, correct?
That is correct, Your
So
Honor.
when one of you tells us that there was already enough law, enough mechanism prior to this law in order to interdict the Lamitan bombing, etc., we will have to take that with a grain of salt, correct? Because has any of the petitioners' counsels been in the position of a law enforcer, specifically those that go after terrorists? That was a question. Have any of the petitioners' counsels, the ones here now, in your knowledge, been in the position to enforce the anti-terror law and to go after a terrorist?
I have no knowledge, and perhaps, Your Honor, none.
I know Attorney Evelyn Orsua, no. I know Professor Molo, no. I know Attorney Jokno, no. I know Attorney Cadiz, no. I know, of course, Congressman Lagman is the wise man of the House of Representatives, but I do not know whether he has implemented or gone after a terrorist. Am I correct?
Yes, Your Honor,
Yes,
but
so-
we did not raise it in our petition, Your Honor.
So we cannot give a lot of weight to a statement that the old law was more effective than the new one, correct? Now, to your knowledge, how many have been convicted under the old law?
Under the old law, to my recollection, if I may correct, Your Honor, there was only one as accessory. This is a case in Regional Trial Court of Midsayap, and it was by virtue of a plea bargaining agreement, Your Honor.
So
And in fact, Your Honor,
so many incidents, yet only one prosecution.
Yes, including, Your Honor, the Marawi Siege, Your Honor. They were not charged with under Human Security Act. They were charged with rebellion, Your Honor.
Yes. So isn't that precisely the point?
There is a law on terrorism, Your Honor, and it is not applied
Yes.
to them. So I
And
do not know why we
Yes,
need
and
another law
probably
like this, Your
the
Honor.
Solgen during his turn will explain to us why the agencies under his representation felt that there needed to be a new law. Is that not correct?
Yes, Your Honor.
Yes. But the other takeaway is extremism is different from terrorism, correct?
That is correct, Your
Yes,
Honor.
and extremism should be allowed because
It is within the realm of truth. There's no overt act,
freedom of
Your Honor.
expression. But freedom of expression by itself does not have value unless there is a philosophical idea behind it, correct?
That is correct, Your
Yes,
Honor.
and John Stuart Mill said, even the false idea is important. Even a false opinion is important because it enables those that in the majority and in the status quo to reveal how they will refute that false idea. And therefore, again, to reiterate the values of the government in terms of that particular false idea. And therefore, the best test of truth is that it is tested in the market. Is that not correct?
Yes, that is the meaning of
Yes.
democracy, Your Honor.
Democracy, therefore, means that every person can be able to speak their mind, correct?
That is correct,
Okay.
Your Honor.
Freedom of expression is protected, but not conduct. Is that not correct?
Yes, Your Honor.
Yes, and conduct can become expressive, like burning a flag, for example, right? So that can be part of freedom of expression, correct?
That is correct, Your Honor.
But certainly violence is not part of protected speech, even though it is expressive, correct?
Yes, Your Honor. That is
If I am
punishable.
so angry with a certain person, I cannot do violence against that person, even if I say that's part of my expression. That's not allowed, correct?
That is not allowed, Your Honor.
Because you curtail the ability of that person to respond to you without coercion in the open. And therefore, you undermine the value of freedom of expression. Is that not correct?
That is correct, Your Honor.
So we punish violence, and therefore, it is legitimate that violence is criminalized, correct?
Yes, Your Honor.
Yes, and that violence can be, or the act to commit a violent act. The intention to commit a violent act, you can punish it, as according to you a while ago, you can punish it even if it is at that stage of overt acts towards that conclusion. Is that not correct?
Yes, Your Honor.
And that's section 4, A, B, C, D, E.
With respect, Your Honor, to the proviso, Your Honor, in Section 4, I think
No, not the proviso. A, B, C, D, E.
in Section A, B, and C, Your Honor.
Engages in acts, overt
is-
act, intended, and the cause is serious harm, correct?
That is correct, Your
So
Honor.
there is an overt act. Look, engage in acts, letter A. Letter B, engage in acts. C, engage in acts. D, develops, manufactures, etc. E, releases. Overt acts, correct?
Yes, Your Honor.
Yes, and as you said, before the accident actually happens, you can prevent it from happening, right?
That is correct, Your
That's
Honor.
why there is no attempt, frustrated stages. Because that is the idea in the concept of addressing, preventing terrorism. Is that not correct?
There must be an act committed first, Your Honor.
Yes. An act which may not have caused the bodily injury yet, but it is in the process of committing. That's where the intent becomes the connection, correct?
There may be act, Your Honor, which is constitutionally protected, Your Honor, which may have an intended effect, Your Honor, that may
Yes, but
cause this.
I will leave it at that because I am sure that my colleagues who are more experts in criminal law than myself will interrogate you on, or some of your counsels on that particular incident, because I heard one of you say that the law punishes intent not act.
This issue, Your Honor, is being discussed by one of my colleagues, Your Honor.
Yes,
I
I
think they're
understand.
proper to answer that.
Yes, that's why I will call him later. And thank you very much, Attorney Latif, for that very enlightening discussion. Can I now ask
You're welcome, Your Honor.
Attorney Neri Colmenares? What is that section regarding? You discussed the section regarding. I think you have
Bill of
overstepped.
Attenders, Your Honor.
You have overstepped your boundary. That is for the Solgen.
Oh,
Yes.
sorry.
That's usurpation. Baka ka makuwaran to. Okay.
Thank you, Your Honor.
Yes. Okay. Now, what is that section regarding arbitrary detention in the Anti-Terror Act?
Yes, that was actually assigned to Congressman Lagman, but Section 29 is on arrest and prolonged detention, Your Honor.
Okay. I'm sure you're familiar with that, and I just want to ask you about that. What does that section actually do?
Well, upon the
It
authorization.
suspends Article 125, correct?
Yes, Your Honor.
Not suspend, but it redefines arbitrary detention for purposes of terrorism, correct?
Correct, Your
Or
Honor.
acts considered as terrorism. Is that not correct?
Correct. And not only that, we argue also that the Constitution is also transgressed.
Okay, what part of the Constitution?
Well, in our opinion, Your Honor, the Constitution limits the days of detention for a prisoner, Your Honor, and that is our contention. And that particular provision we would like to forward.
So this is
was actually
Article 7,
Yes,
Section
18, Your Honor.
18. What,
So-
what again is Article 17, Section 18?
Well, it says, Your Honor, that
It's called the Commander-in-Chief provision,
yes,
correct?
Your Honor.
Okay,
In cases of
a while ago, we clarified that there were two approaches to attending to terrorism. The first approach is the executive approach, which is to treat it as a threat against international peace, a threat against national security, and therefore, like in Section 2, there is a cut-out there. And the cut-out is about executive actions to address terrorism. Like, for
Yes, Your
example, what happened in Marawi. Is that not correct?
Yes, Your Honor.
Yes. So it is calling out the armed forces to address an invasion or rebellion, or simply the calling out power of the president to call out the armed forces to suppress lawless violence. That's all, correct?
Yes, Your Honor.
And I recall that there was somebody among us who dissented and said that's not rebellion, that is terrorism. Is that not right?
I'm not familiar, Your Honor.
You're not familiar.
Yes.
You're talking to him, right?
Oh, yes, Your
okay.
Honor.
But in any case, so what we are saying is, yes, so that is one provision. Article 8, Section 18 is the Commander-in-Chief provision, correct?
Yes, Your Honor.
It prohibits and suspends the writ of habeas. It allows the president to suspend the writ of habeas corpus. Is that not correct?
Yes, Your Honor.
And to suspend the writ of habeas corpus, during its suspension, a person may not be detained for more than 3 days, correct?
Correct, Your Honor.
So the link there is the 3 days is connected to habeas corpus, correct?
Well, in my opinion, Your Honor, it is actually connected
Read the provision.
to all, Your Honor, because if it is an extreme situation where the writ of habeas corpus has been imposed and it limits only to 3 days, the more reason, Your Honor, we argue,
Okay.
of course, that it will also apply
If a person is
in normal
detained
times, Your Honor.
because of the provision now in the Anti-Terror Act, is habeas corpus still applicable to them?
Well, they can resort to that.
Because all it does,
Your Honor.
it says that the rule on arbitrary detention will not apply because the days now will be different, correct?
Your Honor, if the
And
habeas-
therefore, is habeas corpus still viable when somebody is detained under the Anti-Terror Act?
I think it can be argued by the accused, Your Honor, in this case, that since Section 29, the title itself says detention without judicial warrant and the authorization of the ATC was empowered by the law. Therefore, the detention
So when
of
the
that person
ATC
is valid because of the law,
uses
Your
a
Honor.
justification which is not allowed by the law and uses, for example, no designation yet, arrests an individual and keeps that individual for more than 10 days for that matter, habeas corpus is no longer available?
They can, of course,
is there
accused,
anything-
Your Honor, can file a habeas corpus petition,
Yes. Is
but
there
because
anything
the
in
law
the law?
allows the ATC to do that, Your Honor, then the habeas corpus could be dismissed immediately
Yes,
by the
you
judge.
know, Attorney Neri, you are convincing me, correct?
Thank
And if you do not
I
listen
hope so,
to
Your Honor.
you're not listening to my questions, I will not be able to understand from my perspective.
But Your Honor, I was answering your previous question.
I got your answer in the
Yes,
first
yes.
words that you said, and that's
Yes,
my
Your Honor.
preference, correct?
Submit, Your
okay.
Honor.
Now, so you are saying that habeas corpus is not available if a person is already detained under this law. Is that your contention?
The person can still file a habeas corpus petition,
Okay.
but
So
it cannot be
that
even
right
a...
is not removed, correct?
Pardon, Your Honor?
That right is not removed.
Well, the filing itself, Your Honor, but the effectiveness of the remedy is already removed because the
I'm
Terror
sorry.
Council...
When you file a petition for habeas corpus, you file it before a court of law, correct?
Yes, Your Honor.
And the court of law can be the Supreme Court, correct?
Yes, Your Honor.
And you are telling us that when they file a petition for habeas corpus here, we will certainly dismiss it.
Well, Your Honor,
You know
because-
better than Manila Times the result of the action of the court? You know better than us?
Your Honor, please.
Yes.
The,
So we can
the
clarify
title
even-
of the law, Your Honor, is detention without judicial warrant. So the court will say, well, that was valid under the law.
Yes,
That
but
you can be detained
again, as
for
I said,
24 days without judicial warrant.
that is
So
your,
what's
that's your
question?
interpretation, and you do not sit in the bench, correct?
Yes, Your Honor.
Yes, and part of the way that we can clarify is it's possible to file a petition for habeas
Yes, Your
corpus.
Honor.
And when a petition is filed, it is up to the court to attend at that moment to see whether the 3 days or the 14 days will apply, correct?
Yes, Your Honor.
Yes, and proceeding from a theme that I had last time, we wait for that incident, correct?
Yes, Your Honor.
Have you been detained already by this law?
Not yet, Your
Not
Honor.
yet. Have any of your clients been detained under this law?
Many, Your Honor, have
Your
been
petition.
in my petition, Your
Yes.
Honor. Not that I know of as
Okay.
of now, but Your Honor,
Thank you
please,
for the clarification.
Your Honor, please, if I may, the law includes the exercise of civil and political rights within the ambit of terrorism, Your Honor.
Wait, that's not my question. I will ask that from Attorney Chell.
Oh,
So
okay.
let me just go to the question.
Thank you, Your
Just
Honor.
for brevity and for orderly procedure, so that the
Thank
rest
you,
of my
Your Honor.
colleagues can ask the question now, and we might be able to finish today.
Thank you.
And then maybe tonight we will hear the Solgen, and I think we will have another session for that. Okay, but that nonetheless. Okay, now you spoke about surveillance, correct?
Yes, Your Honor.
Yes. Okay. There is Section 2 and there is Section 3 of Article 3 of the Constitution. Is that not correct?
Yes, Your Honor.
Yes. What is the difference between Section 2 and Section 3 in terms of its application of the Constitution?
Well, Section 2, Your Honor, is about the right of the people to be secure in their
The right of the
persons.
people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures
Yes. And
shall be inviolable. And you look at the end phrase, describing the place to be searched and the
Correct.
persons or things to be seized, correct?
Yes, Your Honor.
So the person or thing already exists to be seized.
Yes, Your Honor.
And the person or thing to be seized, person or thing, and thing can be fungible or non-fungible, correct? Tangible or intangible. They already exist, correct?
Yes, Your
In
Honor.
other words, Section 2 might apply, just reading that, might apply when the crime has already been committed, right?
Or about to be committed, Your Honor.
No, it says persons or things to be seized.
Yes,
Therefore,
Your
it is already there, right?
Yes, Your Honor.
Yes. Now look at Section 3. Section 3 actually says, the privacy of communication and correspondence shall be inviolable, except upon lawful order of the court or when public safety or order requires otherwise, as prescribed by law. Now the difference might be, and this is covered in a separate opinion in the case of Subido versus AMLA, the law firm of, I think then, Vice President Binay versus AMLA. The ponente there was Pepe Perez, Justice Pepe Perez, and there was a separate opinion which clarified that Article 3, Section 3 applies to conversations and communication. And the intervention there happens before you speak, and therefore the thing does not yet exist, correct?
Well, Your Honor, under the
Surveillance.
ATA law, surveillance,
Yes.
Your Honor,
No, we're just
it
going to Section 3.
empowers-
Section 3. I'm not yet in AMLA.
Okay.
Section 3 says, privacy of communication and correspondence shall not be violated. Can we go back to Section 3?
Yes, Your
Except upon lawful order of the court, correct?
Correct, Your Honor.
It means, therefore, that there is a law which allows that the communication can be intercepted, privacy of communication except upon lawful order of the court, right? In order to be able to get conversation which has not yet happened. For example, Attorney Neri, you are in my contact list and you are being surveilled.
Yes.
We haven't spoken yet, but when I call you and ask you, magkano ba ang Kalinga Kape coffee mo? That will be what will be intercepted, but the authority of the court comes before the thing exists, correct?
Yes, Your Honor.
Yes. And look at the test in Section 3. Does it say probable cause?
No, Your Honor.
It says lawful order of the court.
Yes, Your
When
Honor.
public safety or order requires otherwise, public safety or order requires otherwise as prescribed by law.
Yes, Your Honor.
Yes.
That's the provision, Your
So
Honor.
this is not Section 2, correct?
Yes, Your Honor.
So surveillance can be allowed so long as there is a law and the law is based upon public safety or order, correct?
But we contend, Your Honor, that surveillance is search, Your Honor, under the Constitution too.
No. Again, look at Section 3.
Yes, Your Honor.
And you said the difference is in searches, the thing already exists. The conversation is already there. That may be applicable for text messages already exchanged. But for surveillance, papanoorin nila kung saan ka pupunta. Susundan ka nila. Hindi mo pa nagagawa. And the lawful order there comes out before you actually do it, before the thing will exist. And all it says is lawful order of the court,
Yes,
number
Your Honor.
1. Public safety or order requires, and this is in the law, correct?
Yes, Your Honor.
So this is met by
the
the
problem,
Anti-Terror Act.
Your Honor, in this case is that we contest the intrinsic validity of the Section 4, Your Honor, because it is vague, it is overbroad, and therefore any resulting lawful order from the court has violated the fundamental rights of the suspect,
I
Your
cannot
Honor.
get the idea that it is vague because lawful order, so the Court of Appeals will issue the order. The law already states that they can issue the order, and therefore the surveillance constitutionally under Section 3, Paragraph 1 is valid, correct?
Yes, Your Honor. I'm referring to the definition of terrorism under Section 4. And second to that, Your Honor, the surveillance section under Section 16 does not only give...
In other words, Attorney Neri, I would like you to cover this distinction. That there are searches that are for purposes of getting the fruit of the crime.
Yes, Your Honor.
And this is already not investigation for purposes of defining whether a person has committed the offense. This is already to gather the evidence for prosecution, period.
Yes, Your Honor.
There is investigation that is criminal in nature, where you are trying to determine whether this person is actually a criminal. That's where surveillance can come in, correct?
Yes, Your Honor.
Yes, and there is this situation for terrorism, when apart from the fact that you want to put it within the rubric of prosecution of crimes, criminal investigation, preliminary investigation, conviction, you also want to stop it. And therefore, you want law enforcers to be able to look at a suspect and be able to find out whether they are in fact planning to put a bomb inside the television, put it in a super ferry, in order that it will kill 116 individuals. Is that not correct?
Yes.
So,
but Your Honor,
you have to, maybe in your memorandum, make this distinction, and I hope the Solgen also can address this, that there are certain instances where the intrusion is not to get the fruit of the evidence, but the intrusion is to prevent terrorism as a unique crime of the 21st century.
as
correct?
long as it's not tantamount to fishing expeditions, Your Honor, and recognize the right to privacy we contend, then that may be allowed, Your Honor.
But there is
in
a
the
certain
case-
degree of, shall we say, there's a certain degree of risk always when you are trying to find out whether an individual, based upon your knowledge, might be a terrorist, correct?
But no unbridled discretion on the part of the
Of course.
enforcement can be
Of
given
course.
by the court.
That
And in
is the
this
basic
case,
framework of our Constitution. There can be no unbridled license. But
Yes.
would it be enough in order to stop somebody from even planting a bomb inside the television and putting it in a super ferry so that it kills 116 individuals? You agree with me
I'm sure current
that
law,
it
Your
is
Honor, will
legitimate,
address that,
that
Your
it's
Honor.
a legitimate public function? Don't debate with me, counsel. Answer my questions.
Sorry.
Let me finish my questions.
Yes, Your Honor.
Yes. So, in other words, it is legitimate for the public, for a public agency to be able to prevent even the putting of a bomb inside the television at that early stage in
Yes,
order
Your
that
Honor.
there is no danger to anyone, correct?
Yes, Your Honor.
Okay. Again, please cover that in your
Thank you.
memorandum. It was you that said last meeting that the old law was already had all the tools
Yes,
in
Your Honor.
order to interdict terrorism.
Yes, Your Honor.
And what's your study?
Well, our contention, Your Honor, there are current laws. The revised penal code panel says
No, I
arson,
mean,
acts
how do
of-
you know that the laws already contained all the tools in order for a law enforcer to interdict terrorism? Have you done that?
Your Honor, I don't have to experience, or none of us have to experience
No
being law
experience.
enforcers.
So
Your Honor,
therefore,
please,
it is only
if I may
based on your
finish,
belief.
Your Honor.
You said no experience.
No.
So therefore, it is only based on your belief, correct?
Your Honors, in the same way that
It
this
is
court
based
will
upon
decide.
your opinion.
No, Your Honors, please, if I may finish.
Yes.
In the same way that this court may not be priests or pastors, but they can decide on whether the practice of religious profession is transgressed, Your Honor.
That's why we
you don't
have-
have to be a part of the media to rule on free press. So I find it, Your Honor, I don't think it's
In other words, you have
necessary
never
for me to
been,
be a law enforcer. To
you have
know.
never been a law enforcer.
No, Your
correct?
Honor.
You have never gone after a terrorist. Is that not correct?
No, Your
You
Honor.
cannot even enumerate to me the high value targets now under the National Security Agency.
No, Your Honor.
You cannot enumerate to me. You cannot know what happened in all of these incidents, why intelligence failed or law enforcers failed.
No, Your Honor.
Yes.
But we always.
Yet you say that they already had all the tools, correct?
Yes, Your Honor.
So you want us to go beyond the wisdom of those that proposed the law, the wisdom of the House, all 300 of them, the wisdom of the 24 senators with some dissents, in order to be able to say, hey, we already know that the old law was better, correct?
It is possible, Your Honor, that they will have or do not have the tools. But the issue in this court is not whether they have or do not have the tools. Because even if they do not have the tools, the court cannot allow a law
That
that will
they
give
have-
them tools and violate constitutional
That
rights,
they had
Your
the
Honor.
tools or did not have the tools is your opinion, correct?
It's my opinion, Your
Yes.
Honor.
And your opinion is just an opinion.
Yes, but that's not
So
the issue
in
in this case, Your
epistemology,
Honor.
it is a belief. It
Yes,
may not
Your
be a
Honor.
true belief. It may not be a justified true belief, correct?
Yes, Your Honor.
So you are just alleging, right?
Yes, but they also contend, Your Honor, that they don't have the tools. So you're on the same
Well, I'm
footing.
sorry, Attorney Neri.
Yes, Your
We
Honor.
have to give them their opportunity to be heard.
Okay, thank
And
you,
we
Your
will
Honor.
want to hear from them also. So you cannot pass on your answers to me by
Yes,
pointing
Your
to a
Honor.
straw person,
I'm
correct?
just saying that we contend.
That's a logical fallacy, right?
Well, we
Yes.
contend, Your Honor.
Thank
in
you,
our
Attorney
opinion.
Neri. Can I now ask Attorney Chell?
Thank you, Your Honor.
Can I just go with you through some basics in freedom of expression?
Yes, Your Honor.
Yes, because you did mention content-based and strict scrutiny
Yes, Your Honor.
during your opening remarks, and I just want to clarify whether we are on the same page on that, Attorney Chell. So there is a range of act and opinion, act, and conduct. Is that not correct? That's
Yes,
a
Your Honor.
range. Yes. And speech and conduct are regulated differently, correct?
Except for symbolic
Primicious
conduct
versus-
that is
yes.
symbolic speech.
Yes,
Your
just the general field
General.
first. Primicious versus Fogoso, you remember that. Reyes versus Bagatsing. Time, place, and manner, where it does not affect speech or does not look at speech, but simply regulates the roads. That's a prime example of regulation of conduct, not speech, correct? And with respect to speech, you agree with the statement of Attorney Latif that violence can never be expressive speech.
Violent advocacy of imminent
No, not
lawless
advocacy.
action, Your Honor.
Violence itself.
Violence itself. I will
Violence
agree with
itself
that.
is unprotected speech because it can be expressive, correct?
Yes, Your Honor.
So expression is different from act. Act can be expressive, and with respect to acts, it must be that it is there. Now, what the Terrorism Act now does is look at speech, correct? In terms of Section 9 at the very least, correct? Let's just focus on Section 9.
Yes, Your Honor.
Inciting, correct? Okay. And when it looks at speech, there are two ways. One is to test speech from the point of view of whether the law invites examination of its content in order to outlaw it, or the other one, whether it invites to look at the content, but it is content neutral. Is that not correct?
Yes, Your Honor.
Yes, and content-based speech is the penalty or the correction comes because of the content of the speech, correct?
Exactly, Your Honor.
Yes, and with respect to content neutral, it is not the content of the speech, but its effects, correct?
The restriction on speech is incidental if
Yes.
it is content
So,
neutral.
I guess you will cover this more in your memoranda because there is a thin line that divides content-based and content neutral. But let me concede with you. If it is content-based speech, okay, we go to that. Advocacy of a violent act, is that constitutionally protected?
Yes, Your Honor. Under the doctrine of Brandenburg, if it is advocacy
Yes.
of violence that is imminent lawless action and likely to
Yes.
cause, then that is not protected. But otherwise, it is still protected speech, Your Honor.
Yes. I am allergic to quoting an American case because of the Philippine flag
Yes,
that flies
I'm
there.
very sorry, Your Honor. May
But
I just
it is
add
covered
that,
by Iglesia ni Cristo.
MVRS
and
case,
later-
Iglesia, and your separate
In diocese.
opinion in, I think, Nicholas Lewis, Your Honor.
No, and Diocese versus Bacolod
Yes.
also called attention to the incitement test in Brandenburg. Okay, let's go to Brandenburg. In Brandenburg, it clearly said, again, admitted into our jurisprudence via the cases that you mentioned, okay, that advocacy of violence is constitutionally protected, correct? But there is an exception, and there are three elements in the exception. If it is directed to inciting or producing, that's one. Second, imminent lawless action. And third, is likely to incite or produce such action, correct?
That is correct,
Yes.
Your Honor.
And Section 9 can be read as containing all of this by the word incitement.
Well, Section 9 does not include those three exceptions, if Your Honor, please.
But the
That's
court
why
can
the
say-
implementing rules
Yes.
attempted to supply
Yes,
that.
but Attorney Chell, you will agree with me that when Brandenburg was ruled in the United States, this was not in the law. This was jurisprudence, correct?
Yes, Your Honor.
Yes. And it's very close to what Learned Hand was kept on saying in Masses Publishing, correct? And finally, it got to the Supreme Court because it was a friend of Learned Hand that actually produced this kind of a decision, correct? So this was not in the law, but the Supreme Court said, whenever there is advocacy, that is protected, but when the advocacy shifts to incitement, this is how it is, correct?
Yes, Your Honor.
As a matter of fact, the concept of incitement is also internationally recognized, right?
Yes, Your Honor.
Yes, there is Security Council Resolution 1624, which calls upon all states in the United Nations to punish incitement to terrorism, correct?
Yes, Your Honor.
At whatever stage it is. This is 1624 of 2005, and that is the actual perambular clause, correct?
Yes, Your Honor.
So under Section 9, we can read it as meaning all of that, correct? Saving Section 9.
If it is read in that way, Your Honor, perhaps, yes.
Okay, so we're done with your case.
No, Your Honor, please.
Yeah, okay, the other point. Section 9 applies only to certain individuals, correct? There is a qualifier. The qualifier there is without taking any direct part. Is that correct?
Yes.
Yes. Taking a direct part in acts of terrorism will be punished differently from incitement, correct? It
I'm
will
sorry.
be punished by Section 4, Section 5, threats, Section 6, proposal, Section 7, conspiracy, correct? So Section 9 only applies to you and me that may not be a participant in the acts of terrorism, correct?
Yes.
Yes, and what you are after is the very broad definition of how the qualifier in Section 4 has been formulated. Is that not correct?
That is another point, Your Honor. If I may, Your Honor, go back to Your Honor's point that we have no more case. We submit that that kind of interpretation would cross the boundary to judicial legislation.
Well, it is freedom of expression, and freedom of expression is a broad, vague, general term in the Constitution. And given the times, a contemporary court may interpret it. But let me go to my other point. Have you looked at the implementing rules and regulations?
Yes, Your Honor.
4.5, last paragraph. Have you seen that?
I believe so, Your Honor.
Yes, and in 4.5, last paragraph, what is the essence of that proviso?
I believe Your Honor is referring to that provision that says that if the exercise of civil and political rights has the requisite intent and purpose, then it may still give rise to prosecution and liability for
So
terrorism.
4.5 actually punishes advocacy simply, not incitement. Correct?
Yes, Your Honor.
Let's look at 4.5, last paragraph of 4.5. If any of the acts enumerated in paragraph A to G, however, are intended to cause death, this is advocacy, then it is punishable as a crime, correct?
That would appear to be
Yes,
it.
this is the interpretation in the implementing rules, correct?
Yes, Your Honor.
And if we strike this down, this implementing rule, this portion only, and go back to the qualifier, which actually says advocacy is exempted, then that would be all right.
Well, there is an inherent flaw in the proviso of Section 4, if I may be allowed to explain, Your Honor, please. Because the exercise of civil and political rights, I think we will all agree, is protected by the Constitution so long as it is peaceful, regardless of intent. I may go out and protest and join an assembly, even if my intent is to be violent, as long as my intent does not cross the line into action.
I understand your point,
that
Attorney
is still protected, Your Honor.
But let us look at Section 4. Section 4, the last paragraph. These are qualifiers to A, B, C, and A, B, C, D, E. Would you agree with me that A, B, C, D, and E are the criminal acts?
Yes, Your Honor.
And the qualifiers are the exempting circumstances, so to speak.
Well, may I qualify my previous answer? A, B, D, and E are obviously criminal acts.
Yes.
A, B, and C are acts, but they're not criminal acts as required by
They're now
UN
criminal acts
resolution
because
and
it's
other.
now provided in the law and punished. Actus non facit reum nisi mens nulla poena sine lege. Now it is punished, therefore it's now a crime, correct? So again, this last paragraph seems to be a circumstance that looks at like an exempting circumstance in the revised penal code, correct?
I'm not sure I would classify it as such, Your Honor.
I will leave that at that, and I'm sure again my colleagues who are more expert on justifying and exempting circumstances will follow that through. When we finish.
May I just point out, if Your Honor, please, that unlike the United Nations definition of terrorism, which requires criminal acts, our law, ABC, I'm referring to 4ABC, took out the word criminal and simply requires acts.
Security Resolution, Security Council Resolution
60, Your Honor.
1566.
Yes, Your Honor, even that.
States that criminal acts. And the United Nations did not prescribe what the criminal acts are. It is up to the domestic jurisdiction to define what they think are criminal acts.
Yes, Your Honor, but criminal acts are different from acts intended to.
If that is the definition in our law, then that becomes the criminal act, correct?
The definition still does not require a criminal act
again,
under our statute.
Maybe just explain in your memoranda, but criminal acts in 1566 clearly state, does not state what kind of criminal acts must be criminalized by the state. It is up to the state to be able to ask that. Well, finally, can I ask Attorney Molo, Professor Molo? Thank you, Attorney Chair. Professor Molo.
Good afternoon, Your Honor.
Yes. When did Justice Carpio stop advocating about the West Philippine Sea?
Did you say stop, Your Honor? Sorry.
Yes, stop.
Stop. He didn't stop.
He did not stop. I thought that he was so afraid that he already stopped.
No.
No, he did not stop. In fact, he went at it. There was another column that I saw, correct?
Yes, Your Honor.
And in fact, if I know Justice Carpio correctly, and I think many of our colleagues know that, he is not afraid of even facing the 1 million People's Liberation Army of China when he speaks about the West Philippine Sea. Is that not correct?
Yes, Your Honor. The
When
entire
did
army is
Professor Dr. J. Batumbakal stop teaching?
He is not stopping teaching, Your Honor.
In fact, he even went to the front lines in the UPDND Accord rally. Is that not correct?
Yes, Your Honor.
And therefore, he was not actually chilled or feared. He's not afraid, correct?
Well, may I disagree, Your Honor?
What about Professor Theodore Te, also your client, right?
Yes, Your Honor.
Did he stop talking about criticisms about this government
No,
because
Your
of the
Honor.
anti-terror law?
No one can stop
He did not.
Professor Te. No.
Yes. He keeps on speaking, correct?
Yes, Your Honor. I can
Through
attest to
media, he writes also in, I don't know, Rappler or Inquirer, I'm not sure now, right?
Yes,
What
Your Honor.
about a Professor Charlemagne Yu? This is Charlie Yu, correct?
Yes, Your
Our
Honor.
friend Charlie Yu.
Yes,
He
Your Honor.
also stopped speaking and criticizing government. Is that not correct?
He's still continuing.
Because he
Your
was chilled, correct?
Honor.
No,
if it-
he still speaks,
he
right?
still speaks, Your
What
Honor.
about the student that ran under stand in UP?
Stand UP, Your Honor.
Is he now cowering in fear inside their homes?
Well, sometimes, Your Honor, because
Oh,
of
really?
the recent, but he
The-
still goes out when he needs to, Your Honor.
Only because of COVID, of course. But for fear of
because of the
speaking out,
recent incident about the UP
yeah. But
hotbed,
in any
of
case,
course.
the point there is, dissent. Inherent in dissent is discomfort. Is that not true?
That is true, Your Honor.
Because in terms of dissent, you speak against a majority or a status quo. Is that not true?
Yes, Your Honor.
And there is always discomfort in dissent, correct?
Yes, Your Honor.
But the discomfort in the dissent does not always justify the content of the dissent, correct?
Yes,
Who
Your
knows that the majority might be right and your point of view might be wrong as of the proper moment. Is that not correct?
Yes, Your Honor.
In fact, in UP, your clients, the University of the Philippines College of Law professors, the listing of your clients,
Yes, Your Honor.
it valorizes courage. Is that not true?
Yes, Your Honor.
It's part of the motto. Hindi lang tapang, kundi giting at tapang. Two kinds of courage. Is that not correct?
Yes, Your Honor.
And therefore, the more that you hit them, the more that you scare them, the more that they will come out. Correct?
Yes, Your Honor.
So they are not chilled.
They are chilled, Your Honor.
They are chilled.
Yes, Your Honor.
So you mean to say Justice Antonio Carpio is cowering in fear?
Not right now, Your Honor. Of
Not
course.
right now. Okay.
But
Again,
within the concept of
Professor Molo,
sorry, Your Honor.
perhaps you can cover this. This is my point.
Oh, yes, Your Honor.
Chilling effect is very subjective. And in terms of your clients, I do not refer to the other petitions, but in terms of your clients, I know them to be professors of the UP College of Law, correct?
Yes, Your Honor.
And professors of the products of the UP College of Law, like you, are trained not to fear anything, correct?
Except
Because
a
you
former
stand,
professor,
you
Your Honor.
stand for somebody, correct?
Yes, Your Honor.
As a matter of fact, do you know that during the EDSA revolt in EDSA, there was a moment where the president declared curfew. You know what happened? There were more people that went there. I was there, right?
Okay, yes, sir.
Where were you during EDSA? Never mind, don't answer me. Okay, but the
EDSA
point there
to po-
is
ano.
they went out. When the ATA law was passed, what happened in UP?
Your Honor, there was some form of protest, Your Honor.
Not some form. It was one of the biggest protests since the pandemic caused the lockdown. Is that not correct?
Yes, Your Honor.
So in other words, isn't chilling effect also a matter of fact?
No, Your Honor.
Why?
Your Honor, chilling effect within the concept of constitutional law does not refer to an absolutely chilled population. It refers to that pause in the writer as he composes his words. It is the hesitation inside the mind of the speaker because of a vague and overbroad law. He doesn't know whether the next word that he will say will be criminal or, in this case, mark him as a terrorist. Justice Carpio is not afraid. That is true. He will never be afraid. I concede that, Your Honor. But it would be another thing to suggest that there is no pause, there's no hesitation. In fact, Your Honor, if I may, because
Counsel, perhaps
Sorry,
you
Your
can
Honor.
just cover that in your memoranda. But as
Yes, Your
far as
Honor.
I am getting you, he is not afraid, but he is chilled.
Yes, Your
So to
Honor.
me, that doesn't seem logical, but I am sure that you will find a way to explain that in your memoranda. But I think I made my point.
Yes,
and
Your
for the other counsels, perhaps to cover that if they feel like covering that in their memoranda. I
Yes,
am
Your
done,
Honor.
Chief. I yield.
Thank you, Your Honor.
Justice Alex, you're next.
Thank
Go
you,
ahead.
Chief.
Thank you.
Can Attorney Jokno yield a few questions from the court? Attorney Jokno, you have a copy with you of your opening statement?
Yes, Your Honor.
Thank you. Attorney Jokno, would you agree to the proposition that the anti-terrorism law was enacted by the legislature in the exercise of police power?
Yes, Your Honor.
Absolutely, right? When Congress decided to legislate the new anti-terrorism law, is it not the fact that the situation has changed from the previous events consisting of terrorist acts?
That is the justification for the new law, Your
Okay.
Honor.
Is there a universal definition for the crime of terrorism?
There is none. The member states of the United Nations have not been able to agree on one, Your Honor.
What could be the reason why there can be no uniform or standard definition of terrorism?
Well, I think it's, Your Honor, please, it is a question of how to identify the essential elements that would comprise the crime. What there is agreement on is that there must be a criminal act or a predicate crime. And
Is it not because terrorism continuously evolved as a crime?
well, while it
Terrorism years ago may be consisting of an actual armed conflict, right?
it may have, yes, Your Honor.
But over the years, terrorism may come in the form of cyber attack.
Yes, Your Honor.
So in other words, the situation is that terrorism cannot be strictly defined in a specific way. Technically, what we have now is a description of acts, correct? That would constitute terrorism. Is that not the case?
Yes, Your Honor.
Okay. Now, you said, if I heard you correctly last oral argument, is that the present law on terrorism is void for vagueness, correct?
That is one of our arguments.
Okay.
Our main argument is that it regulates speech, therefore
Yes.
the strict scrutiny test should be applied, and it fails the strict scrutiny test.
It's in your plastering of, in your manifestation.
Yes,
Anyway,
Your Honor.
and that you consider the old Human Security Act as sufficient for purposes of penalizing terrorism. Is that correct?
We did not make any such allegation in our petition, if Your
But
Honor.
I heard
please.
you said that, the old law, Human Security Act, is better because it enumerates the specific, what you might call it, predicate offenses. Is that not correct? You said that.
Yes, Your Honor, that the old law, the Human Security Act, is more consistent with the international requirements for terrorism because it requires a criminal act or a predicate crime.
Thank you. In your opening statement at page 2, it says that the ATA offers a smorgasbord of acts, intents, and purposes. At the last paragraph of page 3 in your opening statement, do you see that?
Yes, Your Honor.
But what makes the law unpalatable is the fact that it dispenses with the requirement of a predicate crime. So in your point of view, you would rather have the a la carte listing of predicate offense as provided in the Human Security Act. Is that what you're trying to tell us?
Not exactly, Your Honor. What we are saying only is that if a new law will be passed, it should at least require the commission of a criminal act rather than the term acts intended to.
Okay. And you continue saying that which appears to be the norm among nations. Is that the case?
Yes, Your Honor.
And then you cited the directive of EU 2017-541. Is that correct?
That is one of the authorities we cited,
Okay.
Your Honor.
Now, since there is no universal definition of terrorism, and you claim that our definition of terrorism under Section 4 would be unconstitutional based on its text as it is written right now. Is that correct?
Yes, Your Honor.
Okay. Let me show you the terrorism law as provided in the European Convention or the European Union, specifically 2017-541. Okay. Can you take a look at the terrorism in the European Union based on this Directive 2017541?
Yes, Your Honor.
You've seen that, right?
Yes, Your Honor.
Now, the text mentions also nature and purpose. Is that correct?
Yes, Your Honor.
Okay. In fact, when you read the provisions of the European Union definition of terrorism, and you compare it with our own provisions under the new ATA, isn't it that there is some kind of uniformity?
Not exactly, Your Honor.
Yeah, not exactly, but major provisions are the same.
I think one major difference, if I may, Your Honor, is the fact that our law does not require the commission of criminal acts or a predicate crime.
Yeah, but if you look at the statement of the provisions in Article 3, it says member states shall take the necessary measures to ensure that the following intentional acts, as defined as offenses under national law, which given their nature and context, may seriously damage a country or international organization, are defined as terrorist offenses. And you look at the enumeration, starting with paragraph 2A and down up to the last paragraphs. Isn't that the same provisions in our present terrorism law?
I'm sorry, Your Honor, I cannot agree because the EU directive refers to intentional acts and then specifies them or enumerates them by referring to actual actions that attacks on a person's life, attacks on physical integrity, which are all criminal acts, if Your Honor, please.
But exactly, you look at our, can you please post section 4 of the Anti-Terrorism Law as it is presently written? Section 4. There you go. Engage in acts intended.
Yes, Your Honor.
Engage in acts intended.
Therefore,
perhaps the only difference is the way by which our law is written vis-a-vis the way it was written in the context of a common law tradition vis-a-vis our civil law tradition. Because if you look at it, manufacture, possession, acquisition, transport, supply, explosive, practically enumerating the same acts as what is provided in Section 4.
I would say, Your Honor, that sections 4D and 4E refer to actual criminal acts.
The only difference is paragraph C in the European Union is very specific. It mentions kidnapping or hostage taking, which is not present in our present Anti-Terrorism Act.
But in our definition in Section 4, if Your Honor, please, I'm referring to A, B, and C. They refer to acts intended to cause destruction, death, etc., which cover even non-criminal acts. It's the intent that is operative there, Your Honor.
That is if you interpret Section 4 in isolation or in truncated portions. But if you read Section 4 in its entirety, you will be able to see that those enumerations A, B, C, and D, and E relates to the succeeding enumerations of those offenses that are considered in relation to A, B, C, D, and E. Is that not correct?
I'm sorry, I cannot agree, if Your Honor, please. I believe that each of these subsections is one way of meeting the first element. The law seems to define terrorism as having two elements. First are acts, either A, B, C, D, and E.
Can you please,
Second is purpose.
Can you post that Exhibit C of Attorney Jokno? Attorney Jokno, I will invoke the fair use rule because I copied your slide presentation.
No problem.
Is that okay with you?
Of course, Your Honor.
You see, from your point of view, terrorism under Section 4 would only be consisting of two elements. Is that not correct? Based on your slide.
That is my understanding of
That's your understanding. So you have first essential element, second essential element. But if you read the provision of Section 4, that doesn't end on those two basic elements. Because if you look at the later paragraphs of Section 4, it says there, when the purpose of such acts, by its nature and context, do you see that?
Yes, Your Honor.
You cannot isolate the enumerations above in relation to that statement when the purpose of such act by the nature and content. So in other words, to be able to understand what the context of terrorism under Section 4 is you read the entire law.
Yes, Your Honor, and we have.
So in other words,
we do read both elements.
your
to mean-
presentation that as far as Section 4 defining terrorism would only have two elements, would perhaps I would call inaccurate. Because in reality, can you please post, in reality, please go back to this. In reality, the elements of terrorism would be like this, taking into account the specific provision of law. The acts engages in and the purpose, but in between, it says there, you have to consider the nature and the context. So you may say that an act enumerated in A, B, C, D may not be criminal per se, right? And yet, when you relate it to the succeeding provisions of the law, you see the context on how the law should be applied. That will constitute the offense of terrorism. Is that not correct?
It is our position, Your Honor, that even as shown on the screen, the law essentially is composed of two elements. When you speak of nature and context, that refers to how to determine the second element, the purpose. When
Yes.
the purpose of such act by its nature and context. Therefore, our position, if Your Honor please, is that the law really does require two essential elements, which should be both read with each other.
But if you read also the European definition of terrorism, it also speaks given their nature or context.
We have no problem with that part
Exactly,
of the European
but you're
definition,
having
Your Honor.
problems as far as our definition in Section 4 when you're dealing with nature and context.
As I said in our opening statement, our issue, if Your Honor please, is with the dispensing
So let
of
me
the
modify
predicate crime.
Let me modify your two elements of terrorism under Section 4. Is it not the presentation of definition of terrorism under Section 4 should appear like that? The act, the purpose, the nature, and context equals terrorism.
I'm sorry, I would have to disagree, Your Honor. The act and purpose would constitute terrorism. In determining the purpose, one must consider the nature and the context. So
Yeah,
the
but
nature and context are simply
precisely
factors to be considered in arriving at the conclusion.
Precisely, you're saying that there are only two elements, the act and the purpose. And to you, that's the elements. But when you read the entire Section 4, you cannot discount the purpose being taken into account and what context the acts enumerated in A, B, C, D, E were committed by the person.
Yes, Your Honor, we cannot discount the context.
Sorry, you cannot discount that to have an understanding what is punishable under Section 4.
Yes, Your Honor.
Exactly. Now, you also said that it is only in this anti-terrorism law that constitutionally guaranteed rights, political and civil rights, are conflicted in the sense that they are included in the definition of the law. Is that not what you said?
Yes, Your Honor.
But if you read the law, the proviso says, can you flash back Section 4? There is a qualifier. In fact, our terrorism law, if you look at Section 4, is a lot better than the the EU terrorism law, because here there is a black and white statement expressly stated in the law that those political and constitutionally guaranteed rights are excluded as a rule, right? It says there. It becomes only, it will form part of terrorism if those constitutionally enumerated political rights will cause what? The last part. And is not intended to cause death or serious physical harm to a person, right?
The
So
problem,
there is an exclusionary provision.
the problem, Your Honor, with that proviso is that it includes protected speech and conduct. If I may have a minute to explain, if Your Honor, please. I think we will all agree that any exercise of civil and political rights, as long as it is peaceful, is protected, regardless of what is in the mind of
Correct,
the
agree.
protester. So if I were to participate in a peaceful assembly, even if my intent is violent, as long as my intent does not cross the line into
Precisely.
violence, then that is
For
protected.
purposes of
However,
intent, it's required in criminal law that there be a what?
I'm sorry, Your Honor. For
For
purposes,
purposes of criminal law prosecution.
well,
Because you cannot penalize intent for how, no matter how criminal your intent is, you cannot be prosecuted, right?
generally, intent may only be inferred from a criminal act, and our problem
Yes,
with the
there
law
must
is
be
that
what?
it does
An
not
external
require
action that should manifest that what you're doing transgresses the provision of the law. Is
a
that not
criminal
correct?
act, Your Honor. Yes.
Okay. Now, you also said that in your Exhibit D, please plus Exhibit D. I don't know where you got this, but apparently this is a what? A flyer or a post in a website? Exhibit D?
That was taken from the website of the PNP Batak
Okay.
station, if I'm not mistaken.
And in your opening statement at paragraph 3, it says here, this is Exhibit C, right? Anyone, therefore, who tweets for people to attend a peaceful rally could be arrested for engaging in acts intended to endanger person's life due to the danger of COVID infection, Exhibit C. Can you point to me which part of Exhibit C that would penalize a person based on that announcement?
May I approach the slide? I cannot
Sure.
read it from here.
I'm sorry, I reduced your presentation. Where is that? Which part? That based on that posting, it provides a warning that you can be prosecuted under anti-terrorism law because you would pose or cause or endanger person's life due to the danger of COVID infection.
It is in the middle portion, if Your Honor, please, on the right side of the
And
slide.
what does it say?
Participating in a rally or any movement that can cause a serious risk to public safety.
Is that your basis?
We included this exhibit simply to show that that is how one police station is interpreting the anti-terror law.
Yeah, but
Your Honor, please.
that post simply tells you what the law says, right?
No, I would have to disagree with that, Your Honor.
Why? Does it say that you can be arrested for violation of Section 4 because you may cause the spread of COVID?
Well, the caption, Your Honor,
on the basis of that?
the caption, Your Honor, is who is a terrorist? And it is answered by participating in a rally or any movement that can cause a serious risk to public safety. And I don't believe that that is the intent of the anti-terror law, Your Honor, please. Because that would now intrude into the exercise of civil and political rights that is protected by the Constitution.
Yeah, but you said it will endanger person's life due to the danger of COVID infection.
Yes, Your Honor. It says here that can cause a serious risk to public safety. By people gathering in a public place, it could easily be said by law enforcers
Are you sure that the portion refers to public safety?
Well,
because you mentioned here endanger person's life due to the danger of COVID infection. Is that an issue of public safety?
It is an issue of public safety, Your Honor.
Are you sure?
That is my understanding, if Your Honor, please.
Because if you look at the Constitution, okay, public safety and public health are two distinct constitutional concepts. Is that not the case?
I believe that issues of public health may endanger public safety as well, Your Honor.
No, because the Constitution is very clear. There is a distinction between public health or public safety. And the only reference to that is in Section 6 of Article 3. See? The right to travel shall not be impaired except in the interest of national security, public safety, or public health as may be provided by law.
While it is true, Your Honor, that Section 6 differentiates between the two, I do not believe that fine distinction would be understood by law enforcers.
So you're presuming that an ordinary citizen cannot comprehend what the law on terrorist section
What I'm saying, Your Honor, please, is the term public safety is broad enough to include issues of safety of people that may come
If
from...
that is the case, then why did the
their health.
Constitution make a distinction between public safety or public health?
Aside from Section 6, I'm not aware of the Constitution making that distinction, Your Honor.
That's the only basis that we can say that there is a distinction between public safety and public health. Is that not true?
My understanding is that they may overlap, Your Honor.
Okay. Thank you, Attorney Joke. Now you mentioned that the anti-terrorism law, based on your manifestation, is unconstitutional by reason of the doctrine of void for vagueness. Is that correct?
That is one of our arguments, Your Honor.
And then you mentioned that it violates the right of a person to, or the accused, to be informed of the nature and cause of accusation against him, right?
Yes, Your Honor.
In fact, the underlying principle to determine the validity of a statute applying the void for vagueness doctrine is that test is that of notice. Is that correct?
Fair notice, Your Honor.
Fair notice. Now, fair notice means simply being a person of common understanding, being able to know whether his acts or omission is covered by the penal statute. Is that not correct?
That is correct, Your Honor.
And the reality of it is that when you talk of understanding or being notified as to the effect of a statute, penal at that, on the individual, would mean this simply mean what? It appeals to a person's common sense. Is it not?
It is understood by the person.
It is understood by measuring with a person's common sense. Because a person absent mentally challenged would know whether what he is doing or intend to do or fail to do will be covered by the law, right?
Yes, Your Honor.
Exactly. And therefore, when you talk of notice, it relates to that constitutional provision on the right to be informed of the nature and cause of accusation against him, right?
Yes, Your Honor.
In fact, authorities, can you flash the recent decision on Dimaya? Sorry, Justice Jonen, I have no choice but I have to refer to U.S. cases because we derive the doctrine of void for vagueness on U.S. jurisprudence. By the way, Attorney Jokno, at what point in time can an individual invoke void for vagueness as a defense?
Well, our understanding based on the Dicini case, Your Honor, is that it can apply to a facial challenge together with overbreath.
At what point in time? Meaning, at what point may a defendant?
As long as the requirements for a facial challenge are present, Your Honor, it could be part of
talking
a
about
facial challenge.
void for vagueness.
I'm sorry, Your Honor. I'm afraid I don't quite get your question.
The doctrine of void for vagueness is actually a matter of defense. Is not that correct? To avoid prosecution?
That is one of the ways it is used,
Yes.
Your Honor.
Yes. And at what point in time, usually, based on your readings of jurisprudence on the doctrine of void for vagueness, at what point in time is this usually invoked?
It may happen when there is an actual prosecution. However, there is
Exactly.
there are
When there is
jurisprudence that allow a facial
there is
challenge.
already an actual prosecution, right? In other words, void for vagueness may be invoked as a rule either at the time of arrest or after conviction. If you look at the jurisprudence, is that not correct?
Yes, Your Honor. That is one of the ways it
And
can
therefore, void for vagueness would apply only if there is an actual case.
if there is an actual case, but it may be used as a ground for facial challenge if we
But the
follow
rule is
the
that there
Dicini
should,
ruling, Your Honor.
you can raise that as a defense when there is already an actual case, because Either you are arrested or convicted. Is that not the trend of jurisprudence on void for vagueness?
Yes, Your Honor. However, there are situations where we
In other
cannot
words, there
wait.
could be something like peremptory challenge, even before the law is implemented. You can raise that. Is that correct?
Yes, Your Honor.
Okay. Now, right. According to this case of Dimaya, vagueness doctrine represents a procedural, not a substantive demand. Meaning that when you talk of void for vagueness, you should look at it from the point of view of procedural due process. Is that not correct?
I believe the first test, the completeness test, may be looked at as a procedural test.
Okay.
However,
If
the
it's a
second test, as
procedural-
far as providing whether it gives sufficient standards to law enforcers to implement, I believe that
That's the
is
second
substantive.
part.
Yes, Your
That's
Honor.
the second part. But basically, the void for vagueness doctrine is essentially an issue of procedural due process, right?
For the first part of the test, yes.
Yes. So when you speak of procedural due process, we talk about how a person is to be prosecuted under a penal statute. Is that not correct?
Yes, Your Honor.
Okay. The Constitution says, can you take that? Okay. It says in Section 14, second paragraph, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, etc. To be informed of the nature and cause of accusation against him. That is the essence of procedural due process, right?
Yes,
The
Your Honor.
law that hears before it's condemned.
Yes, Your Honor.
Is that correct? Now, proceeding from that premise, if a person is accused, okay, under Section 4 of the Anti-Terrorism Law, the information will not enumerate the substantive law enumeration under Section 4. Is that not correct? You do not restate the elements of Section 4 if one is to be prosecuted for violation of Section 4. Is that not correct?
The information must allege the material elements of the
Under Section
crime
6
constituting
of
the
Rule
crime.
110, a complaint or information is sufficient if it alleges the acts or omissions complained of as constituting the offense charged. Is that not correct?
That is correct, Your Honor.
In other words, the basic elements provided in Section 4 is given flesh in an information by way of allegations of specific factual matters, right?
Yes, Your Honor.
That will put into the definition of the offense. Is that not correct?
Yes, Your Honor.
Okay. Since the issue when void for vagueness is the lack of notice, which is equivalent to the right to be informed of the nature and cause of accusation against the person, is that not correct? The term notice would refer to the right to be informed, right?
They are connected, Your Honor.
Exactly. And in that section, it says, in all criminal prosecutions, which is judicially defined as that starting from arraignment up to trial, right? That is the duration of criminal prosecution. If at the arraignment, the accused charged under Section 4, under an information which alleges all the factual circumstances consisting of acts or omission constituting violations of Section 4, at the arraignment, if his counsel explains to him, which is under the rule on arraignment, it's important that the information must be explained to an accused, right, in a language understood by him. And if necessary, it has to be translated. Is that not correct?
Yes, that is correct.
And therefore, if the lawyer is able to explain to his client the specific allegations that matches the elements of the offense, there is no violation of the right to be informed. Is that not correct?
That is correct, Your Honor.
And therefore,
may I just add, if the information itself contains all the material
yes, exactly,
elements.
because that's what Section 6 says. Sufficiency, right, of information, the allegations as to the acts or omission, and all the aggravating and
Yes,
whatever
if
circumstances.
all of those are contained.
All of those, if they are contained in the information, that would be a valid information, right?
Yes, Your Honor.
And if there is lacking allegation as to the elements, okay, vis-a-vis the factual allegations as to acts or omission, you can move to quash, right?
That is correct.
That
Your
is your remedy. And in fact, if you do not find the allegation sufficient to your client as to its clearness, you can ask for a file a motion for bail of particulars. Is that not correct?
Honor. Yes, Your Honor.
In other words, the right to information or notice is possibly given at the time the accused is arraigned, and you will not violate his right. You will not violate his right to be informed. Is that not correct?
As far as the right to be informed
Because
is
you
concerned.
explained to him vis-a-vis the requirement of void for vagueness as to notice of what you are being charged. Is that not correct?
Well, the right to be informed, if Your Honor, please, is not dependent on how well counsel explains to the accused what the elements are contained in the information. The right to be informed of the nature and cause of the accusation is a constitutional requirement that the charges
Must be clear.
be clear. Yes, Your Honor.
Precisely. It must be clear to him and he must understand the charges.
Yes, Your Honor.
And therefore, the void for vagueness will disappear because the lawyer explained to him exactly what are the terms by which he is indicted. Is that not the case?
If Your Honor, please, while the two concepts are connected, I believe that the void for vagueness is a different concept from the right to be informed because it has two different elements. One is fair notice to the citizen,
We're talking
and the
here-
other is proper standards for law enforcers.
I know. These are the two twin facets of
That is
void
not
for
found in
vagueness.
the right
The
to be
first,
informed.
as I said earlier, I premised it that the crucial element for purposes of invalidating legislations on the reason of void for vagueness is that essence of notice, right?
May I respectfully disagree, Your Honor? In the Dicini case, the crucial element of void for vagueness was the lack of proper standards to guide law enforcers, such that enforcement of the law would be arbitrary.
Okay. Let me go to another point. Look at that slide on terrorism as defined under Australian law. Is there much difference from our provisions on terrorism under Section 4?
Based on my very quick glance at it, Your Honor, I would say that it does not, it does require still actions that are criminal in nature. That
Yeah,
is my
but
understanding.
if you look at, you were saying that you object to the definition of anti-terrorism law because it violates your free speech clause, right? Huh? Is that what you're telling us earlier?
Section 4 in relation to Section 9, 5, 6, 8, and 10
We'll
regulates
go to that
speech.
later.
That
We'll
is
go to that.
our
But in the meantime, you're
position, Your
saying
Honor.
that the definition, okay, affects or rather impairs your constitutional right of free speech, right? Is that what you're saying?
We are saying that the definition, Your Honor, is overbroad and void for vagueness.
Yes, because it impairs your constitutionally guaranteed political civil rights. But look at the paragraph 3 of the Australian terrorism law. What does it say?
It refers to advocacy, protests, etc., Your Honor.
Yes, and you relate that to paragraph A of section 101. It says there, the terrorist acts means an act or threat of action where A, the action falls within subsection 2, right? But does not fall within subsection 3, right?
Yes, Your Honor.
And we have the same provision in section 4 of our on definition of terrorism. It says that it does not fall is advocacy, protest, dissent, or industrial action, and is not intended to cause serious harm. Is that not the same practically? It's
Yes,
just
Your
a
Honor,
textual
but
presentation that makes the difference.
I am not aware of whether the jurisprudence and the Constitution itself of Australia are the same as the jurisprudence and understanding we have
But we're
in our
talking
country,
here
Your
of
Honor.
terrorism as an internationally recognized crime.
Yes, Your Honor.
And
However,
there is
the law,
commonality in terms of definition of terrorism. I'm just citing to you that as far as Australian Commonwealth, this is one of the forerunners in fighting terrorism, practically our provision is, if not a verbatim, but obviously they are the same.
well, the definitions may be similar, Your Honor. The treatment, as far as the courts are concerned, I cannot say they are the same because the jurisprudence there is probably different from the jurisprudence here.
Are you telling us that with those exactly the same words, they can be interpreted in different jurisdictions?
Well, I can only speak for what we have in our country, Your Honor. And I believe it is very clear in our country that any kind of peaceful exercise of civil and political rights, regardless of the intent,
In fact,
is protected by the
would you not
Constitution.
say that we are better off because there's an, as I said earlier, there is a black and white statement under Section 4 that those political or civil rights are excluded, subject only to that last provision?
The problem, Your Honor, is not black and white. If the proviso simply said that terrorism does not include the peaceful exercise of
Exactly.
civil and political rights, period, there would be
Unless-
no problem. However, it does not say that. It said it removed the word peaceful and replaced it with intended to. And that now gives a window for the enforcers, even if a exercise of rights is peaceful, to still say your intent, the intent of this person is to cause, etc. And therefore, even if you are exercising your rights peacefully, you could still be committing
Okay.
terrorism. That is our problem with the
Can you post
definition,
that
Your Honor.
picture of the translation in Quiapo? There is a slides that we took up from Al Jazeera and I think Philippine Star. Okay, that is a mass action. Is that not correct?
It would appear so. I'm not familiar, Your Honor, with the pictures, but it would appear
No,
so.
that is a picture taken during the celebration of Translation in Quiapo.
So a religious gathering,
Okay.
Your Honor.
That's a mass action, right?
Yes, Your Honor.
Okay. Can those people who participated in that mass action be prosecuted for anti-terrorism under Section 4?
If the law enforcer reads the law and says that
No,
under
per se,
the law
per se.
they are engaging in acts intended to cause
Exactly.
death or
Per
endanger
se.
persons' lives.
In first, you look at the pictures per se. Okay? Can they be prosecuted at mass gathering?
That is precisely our problem, Your Honor, with that section.
Yeah.
That because it says it includes acts intended to endanger persons' lives, under the pandemic, the physical act of gathering together is already
But
an
if you
endangering
look
of
at the
persons'
entire
lives.
context of the law on terrorism, that mass gathering there will only be covered if you took into account what is provided in the law, which is what? The purpose, nature, and context. Context, is that right?
Yes, Your Honor.
And this purpose, nature, and context becomes evident when there is an external action, right?
Well, if the same photograph, Your Honor, showed demonstrators holding up placards calling for the president
That is
to
precisely
step
what
down,
I'm trying to drive
etc.
at. To be able to know whether you are punished, whether your act is punishable under the anti-terrorism law, you have to prove the purpose, the context, and the nature of that mass action.
You have to prove the purpose, and that is done
Exactly.
by looking at the nature and the
But not,
context, Your Honor.
contrary to your statement that every mass action puts in doubt whether you can be prosecuted or not under the anti-terrorism law.
Well, not every mass action, but definitely some types of
Precisely,
mass
to be
actions.
able to know whether they are covered by that provision of law, you have to consider, and the prosecutor should be able to allege in the information that the purpose, the nature, and the context fits within the definition of Section 4 of the Anti-Terrorism Law. Is that not correct?
It would also depend on the intent, Your Honor, because the first element or the
intent, you
first portion
cannot-
of Section 4
intent is
requires
something
not only acts, but acts intended to a certain purpose.
Yeah, but
so there
you-
are two elements of state of mind, Your Honor, please, in the law. The first is acts intended to, so you still look at the subjective
But you do not
state of
isolate
mind.
that intended with purpose. Because otherwise, you cannot say that whether your acts or omission falls within Section 4.
The law, yes,
Because
requires...
you have to look and analyze to determine whether an act or omission is covered by Section 4 under the terrorism law. Because aside from the enumerations of acts intending to, you have to consider the succeeding paragraphs and the rest of the provision of the law. You cannot isolate that.
The law requires a requisite intent and purpose, and they are separately provided in the law.
Correct. But you do not limit the interpretation of Section 4 solely on the basis of intent and purpose. Because you have to consider the nature of the act and the context by which the act or omission was done. Is not that the case?
To determine the purpose, yes, Your
To
Honor.
determine whether or not that act or omission falls within the definition of Section 4 of the Anti-Terrorism Law. Is that not the way we should read the law?
That it requires both a requisite intent, acts intended to, and a purpose which is all to be determined by the nature and
Let me go
context.
to
Yes, Your
another
Honor.
point. In your opening statement, you also mentioned this. Where is that? Here. First page. The ATA punishes speech based on its content. Section 4, defining terrorism, mentions advocacy, protest, mass action, which are all forms of expression. Section 9 punishes inciting others by means of speech to commit terrorism. Sections 5, 6, and 8, and 10 punish threats and proposals to commit terrorism, training, recruitment, so on and so forth. What are inchoate offenses? Attorney Jokno.
Well, my understanding is that they are offenses that have not yet blossomed into an actual consummated crime.
Are inchoate offenses punishable under our jurisdiction?
Well, the anti-terror law does state that regardless of the stage of execution, these acts are punishable.
Other than the anti-terror law, do we punish inchoate offenses?
Yes, Your Honor, there are certain occasions when that is
And
done.
when you talk of inchoate offenses, there is a target offense.
Yes, Your Honor.
And what is the purpose? Why do we penalize these inchoate offenses?
Well, because of the perceived evil to the state.
So in other words, you can penalize inchoate offenses as a preventive measure so that the target crime should not occur, right?
Yes, Your Honor.
Exactly, that is the reason why there are those provisions in the nature of inchoate offenses in the anti-terrorism law to be able to prevent the actual happening of a terrorist act, correct?
That appears to be the
And
purpose.
along those inchoate offenses also is the authority or as Justice Leonen said, there should be tools to prevent the commission of the actual terrorist attack. Is that not the case?
Yes, Your Honor.
So in other words, those enumerations under the anti-terrorism law, which are in the nature of inchoate offenses, must be punished with the objective precisely of preventing a terrorist attack. Is that not the case?
As long as, Your Honor, they do not stifle broadly on fundamental rights, and that is our position, that these particular sections, which are content-based restrictions on speech, stifle protected speech.
Taking from your that statement, if, for example, there is a training camp somewhere in Mindanao training jihadist fighters, and there is somebody who is teaching them how to make IED device, is that covered by protected speech?
That is not covered here.
Obviously. So the context must be taken into account whether or not that free speech is in violation of the anti-terrorism law. You
Our
cannot generalize that every speech is protected because the right to speech is not unrestricted, right? Jurisprudentially determined that it's not absolute, right? It is subject to certain restrictions, right?
Yes, it is also clear, Your
And the
Honor, from
typical
our...
example, as we studied in law school, is you cannot shout fire, fire inside the theater, right? Do you recall that case?
Yes, Your Honor. It's also
Okay.
clear from our jurisprudence that advocacy of lawless action is only punishable if it is imminent lawless action and it is likely to succeed.
Now let me go back to notice. According to the Boyd for the Vagueness Doctrine, notice is essential because I want to focus because that's really the reason why there's such thing as Boyd for vagueness. Why cases reaches the Supreme Court?
I'm sorry, Your Honor.
Why cases reaches the Supreme Court?
Why do cases reach the court?
Yes.
Well, because the counsels in those cases are not content with the rulings below if it came from a lower court.
And the mode by which a case as a general that reaches the Supreme Court is under Rule 45, correct?
Yes, Your Honor.
Purely question of law.
Appeals by certiorari.
And you will admit that even the text of the law is so clear, it reaches the Supreme Court under Rule 45. Is that right?
There may be occasions when that is true, Your Honor. However, we submit that this case is not one of them.
Yeah, but the reality and actuality is that even if the text of the law is so clear, right, and gives you proper notice on how the law should apply, still they question what?
We submit that this case is different, Your Honor, from those cases. We submit that the law in this particular case, in terms of providing fair notice to the ordinary citizen, does not satisfy that test.
Is it your contention that it is a must that there be predicate offenses for purposes of anti-terrorism law?
Our contention is that that appears to be the norm among nations, that either a predicate crime or a criminal act is required.
So this anti-terrorism law is a new development, correct?
Yes,
in
Your Honor.
response to what's happening in the world right now.
Yes, Your Honor.
Okay. Now, coup d'etat did not exist until after EDSA, right?
Yes, Your Honor.
Okay. In fact, in the beginning, those who took part in these activities were charged under rebellion, correct?
That is correct, Your Honor.
Okay. But Congress saw it the necessity to provide an autonomous offense of coup d'etat, right?
That is correct, Your Honor.
And it is now under Article 134-A of the Revised Penal Code, right?
Yes, Your Honor.
Take a look at how coup d'etat is defined under 134-A. How committed? The crime of coup d'etat is a swift attack. Is that not so broad?
No, Your Honor, it's still a criminal act.
No, no, no.
It's an attack. Therefore, it's
yeah, but when you
clear.
say swift attack, is that not broad?
Not in my opinion, Your Honor. I would not say.
If somebody uses a samurai and decapitates, is that a swift attack?
Well, the words swift attack are qualified by the...
Exactly. Qualified by the other elements of the offense. Is that
Yes,
not
Your Honor.
correct? So in other words, when you interpret Section 4, you should also consider the qualifiers in the provisions of the law.
Yes, Your Honor, and that's our
Exactly,
problem.
that's
The
what we're trying to
qualifying
say.
provisos in Section 4 are
provides certain
problematic.
acts and then certain purpose, but subject to certain qualifiers to be understood as falling within the provision of Section 4. Is that not correct?
I believe Your Honor is referring as a qualifier to the proviso portion, the last part of Section 4.
Oh.
Our problem with that, Your Honor, as I mentioned earlier, is that it is based on a flawed understanding of the Constitution. That the exercise of civil and political rights, if the intent is wrong, can already be punishable. We submit, Your Honor, that the exercise of civil and political rights, so long as it is peaceful, regardless of the intent in the mind of the actor, is protected. And that is not considered by the proviso in Section 4, Your Honor.
Okay, thank you, Mr. Jokno. May
Thank
I
you,
ask
Your
the counsel for the last, just one question, Mr. Chief Justice. Attorney Latif. Thank you, Attorney Jokno. Attorney Latif, in your petition, you are saying that the anti-terrorism law is unconstitutional because under the repealing clause, it repealed the Human Security Act. Is that correct?
Particularly with respect to Section 40, 41, and Section 50.
Which refers to what?
Your Honor, please.
What are you referring to? What are those provisions that you are saying that by reason of the repeal of Human Security Act under the anti-terrorism law, what are those provisions that you are referring
You
to?
refer, Your Honor, to Section 41 and Section 15 of the Human
And what are
Security
those sections provide for?
It provides for 500,000 penalty compensation in the event that the accused is acquitted, Your Honor.
In other words, those provisions in the Human Security Act guarantees compensation by way of damages, right?
That is correct, Your Honor.
Okay. Take a look at Article 35 of the Civil Code. This plus Section 35. What does it say? Independent civil actions. Can you read it, please?
I cannot read it, Your Honor.
Oh, sorry. It simply says, and we know this, Article 35 of the Civil Code provides that any violations committed by an officer or even a private individual in violation of guaranteed constitutional rights entitles that person or victim to damages. Will that not provision of Article 35 answer your will not be sufficient to address your concern as far as the repeal of the provision of the Human Security Act on compensation?
It will not, Your Honor, because Section 41 and Section 50 of the Human Security Act specifically provides for 500,000 compensation per day of...
in other words, your disagreement is as regards the amount.
Not only the amount, Your Honor, the provision per se, Your Honor, because Civil Code did not provide particular amount of award, Your Honor.
Yeah, but damages are subject to proof. Is that not correct?
But in this case, Your Honor, in Human Security Act, there is no proof required, Your Honor. The only proof required, Your Honor, is as long as a person...
So your question is to the amount that may be recovered. Is that not correct?
Yes, Your Honor.
Oh, I see. So there is no issue that you can avail of Article 35 if you want to recover damages from violators under the anti-terrorism law. But only your concern is the amount which was guaranteed under the Human Security Act.
Not only that, Your Honor, under Section 41 and 50, Your Honor, the only proof, Your Honor, required to a person is that he is acquitted.
He's acquitted?
Yes, Your Honor.
But look at those provisions of Article 35. Does it mention there those who are wrongfully charged? Is it not there? Huh? Can you flash down the other part? See?
Still, Your Honor,
See? The right against deprivation of property without due process of law, so on and so forth. Practically enumerating all the fundamental rights you can recover for damages. And this requires only preponderance of evidence.
Yes, Your Honor. Precisely, Your Honor, in Section 41 and Section 50 of Human Security Act, Your Honor, it is our submission, Your Honor, that it is conclusive. Once you are acquitted, Your Honor, you are entitled to 500,000, Your Honor. That is the reason, Your Honor, that only one person was convicted here based on plea bargaining. In fact, Your Honor, in the case of Marami...
So in other words, you are not satisfied with the guarantee under Article 35 of the Civil Code that you can recover damages?
Yes, Your Honor, we are not satisfied, Your Honor, because there should be a guarantee of non-repetition of the acts committed, Your Honor.
Okay, so in other words, instead of litigating under Article 35, it is your view that since Human Security Act fixed the amount, that should be the one to be followed. Is that not correct?
Yes, Your Honor, because it favors, Your Honor, the victim, Your Honor. And you can only prove it with minimal amount of evidence.
Okay, thank you, Mr. Attorney Latif.
Thank you, Your Honor.
Is Hernando, please.
Just a few questions, Chief. Attorney Diokno, please.
Good afternoon, Your Honor.
Good afternoon, Attorney
Good afternoon,
Diokno.
Your Honor.
You know, last week, right after the first oral arguments, I happened to watch on YouTube Representative Lucy Torres, and where she was explaining how Congress came up with the bill that eventually became this Anti-Terror Act. And I was struck not just by her beauty, but by the fact of her bemoaning that critics of the law seem to be instilling fear of the law itself in the people, instead of instilling fear of terror, which the law is trying to address. So now we're here to hear your arguments against the validity of the law itself. Would you say that there is any saving grace to the ATA, Attorney Diokno? Or would you want the entire law to be struck down as unconstitutional?
I'm sorry, Your Honor. I don't think my microphone is working, Your Honor.
It is, we can hear you.
I'm sorry. Unfortunately, Your Honor, given the way that the law defines terrorism in Section 4, we see no way that that can be saved.
So it's only, what you would want is only a partial striking down of the law.
Well,
only Section 4?
Well, Section 4 defines terrorism, and the rest of the provisions of the Anti-Terror Act implement that definition of terrorism, Your Honor.
Well, there are other provisions in the law, such as proposal to commit treason, etc., etc. So you would think that striking down Section 4 itself would effectively invalidate the entire statute.
That is one of our submissions, Your Honor.
I see. Let's just go into some practical questions and applications of the law. If, let's say, those two ATAs who had been arrested by the police recently were to engage your services as counsel, what would you do to protect their rights under the ATA?
Well, I would, of course, look at any possible attacks that could challenge the law as applied to them, Your Honor.
Would you immediately question their detention under the ATA on the ground that they're being held arbitrarily by the police?
If the facts were to show that they were not lawfully arrested, then I would probably do that, Your Honor.
Mm-hmm. You would question their detention if, let's say, it lasts beyond 3 days, because it would be against the Constitution.
That could be a possible argument I would raise. It's very hard to say unless I get to confer with my clients and determine what really happened, Your Honor.
Okay. If, let's say, they're now on the 10th day of their detention, then you could possibly argue that they are being held beyond the period of detention that is allowed under the Constitution, which is 3 days.
That is an open argument, Your Honor, yes.
All right, but going into the 3-day period in the Constitution, I remember that when it was crafted into as part of the Constitution by the Constitutional Commission, the intent was that it would cover only detention by reason of rebellion or insurrection, and when there is suspension of the writ of habeas corpus, isn't it?
That is the literal wording of the Constitution, Your Honor.
Yes. So we would have to interpret, therefore, the Constitution in that manner strictly. And that is to mean that, or that is to say that the 3-day period would only refer to the detention in case of rebellion or insurrection and when there is suspension of the writ of habeas corpus. In other words, and I remember this vividly when Commissioner Padilla talked about this particular provision of the Constitution, he meant that it shall cover only rebellion or insurrection, and when there is suspension of the writ of habeas corpus. In other words, it was left to Congress to determine another period for detention with regard to other offenses. And this would already entail exercise by Congress of its policy-making process in crafting laws. So I would say that we could possibly interpret the ATA as one such act in which Congress can extend the 3-day period.
Well, that is not part of our petition, Your Honor. My understanding is that the argument goes like this, that, well, in the Constitution, we consider martial law, invasion or rebellion, suspension of the writ, as the gravest of emergencies that could ever face a country. And if for that kind of grave emergency, you can only detain a person without charges for 3 days, our submission is that that should apply across the board, even to other crimes, including terrorism.
But in the deliberations of the Constitutional Commission, they expressly left out offenses under the RPC and other acts that may be defined by Congress as criminal offenses.
Well, that Section 18 really does refer, Your
125
Honor,
did not trivialize.
It really does refer to invasion and rebellion, Your Honor.
No, I mean the Constitution did not interfere with 125 in any manner, no?
No, Your Honor.
Yes, which is why there was that expression by Commissioner Padilla that the 3-day period in the Constitution should only be interpreted to cover rebellion, insurrection, and when there is suspension of the writ of habeas corpus. So that means to say that Congress can, in fact, come out with a statute that would lengthen the period of detention in another offense that it would define, like terrorism under the ATA.
Well, the Constitution expressly makes that reference, if Your Honor please, to invasion and rebellion. It's our submission that the intent or the spirit of the Constitution was to provide that as a maximum cap, that when you have the gravest of emergencies like an invasion or rebellion, the most that you can detain a person is 3 days without charges. And we submit that that should apply across the board to all other offenses.
All right. The fear of terrorism is now so pervasive worldwide, no? Which is why we have practically all nations coming up with their own respective anti-terrorism acts or laws.
That is correct, Your Honor.
In Southeast Asia, would you know which countries have come up with anti-terror laws like ours?
I have not made a study, Your Honor, but I do know that probably all the ASEAN countries have anti-terror laws.
Yes. For instance, Indonesia has one. The period of detention is 2 days plus extension of 120. No? Pakistan, 30 days. Malaysia, 59 plus 2 years extension. No? And Singapore is tops 730 days plus indefinite detention. So these countries obviously recognize that terrorism is such that it has to be nipped by all costs in the ban.
Well, we submit, if Your Honor please, that those laws may be valid based on the constitutions of those respective countries. And I believe we're familiar that we know that Malaysia and Singapore in particular have always been have always favored the interests of the state as far as detention is concerned. I believe Malaysia has had a preventive detention law for many, many years, and the same with Singapore.
Well, but just like nations who are part of the United Nations, I'm sure they crafted this in accordance with UN security regulations. No?
Well, that is a subject,
that is
perhaps
to be the presumption.
Yes.
All right. Now, we've been hearing a lot about the ATC, the Anti-Terrorism Council. And judging from news reports and criticisms and so on and so forth, the ATC is made to appear like it's the KGB, no? But who composed this ATC, Attorney Diokno?
I believe, Your Honor, the ATC is chaired by the Executive Secretary, and the members consist of the cabinet level officials from the Executive Department, Your Honor.
Yes, Secretary of Finance, Secretary of Justice,
Yes, Your Honor.
DILG, DFA, etc. No?
Yes, Your Honor.
In other words, these are not people on horseback. No? They are members of the cabinet who are there to assist the president and the country to see to it that security of the nation is preserved. Now, when it comes to the designation by the ATC, let's say of a person as a terrorist, can the policeman immediately arrest that person by reason of that designation?
From the literal wording, Your Honor, of the anti-terror law, it would appear that they can.
I
It's
don't
our
think so.
position.
Because if you would read the ATA, Attorney Jokno, that designation is only a preventive measure by the ATC preparatory to filing a freeze order with the AMLAC. It's not meant as an instrument to arrest people. I think that should be made clear to all the petitioners. So it's only a tool so that the funds of the terrorists can be frozen by the state in order to be taken into custody and not be used anymore for any act of terrorism. Now, also, would the act of designation by the ATC be a basis for the police to already conduct a surveillance on the designated person?
If I may, Your Honor, Section 29 on detention without judicial warrant is broad enough to include a person designated by the Anti-Terror Council because it makes reference to a person suspected of committing. And when one has been designated by the Anti-Terror Council, I believe that would give rise at least to an inference that he is suspected of committing a terrorist act. Therefore, it would give authority to law enforcers to effect an arrest.
Already a warrantless arrest?
It would appear to be so based on the wording of Section 29, Your Honor.
But isn't it that when Congress deliberated on the warrantless arrest feature in the ATA, they meant this to cover the situations in Rule 113, Section 5. In flagrante delicto and hot pursuit. That's what I have researched on. No? Legislative intent is to limit the warrantless arrest to those under Section 5 of Rule 113, which refers to warrant arrest for all kinds of offenses.
If that were the case, Your Honor, then why would there be a need for a 14-day prolonged detention? If the arrest was made in flagrante delicto, there is more than enough evidence to hold that person. There's no need to gather evidence. The Senate deliberations would appear to show that the reason they asked for a 14-day or 24-day detention was so that they could do a proper case build-up. But if this provision refers to Rule 113, there's no need for a prolonged period of detention because the evidence is already there by the fact that they were caught in the act of committing a crime.
Well,
there's no
that's
need to
because
build up the case.
that's in recognition of the fact that terrorism is a different kind of offense, no? Where police would need to dig deeper. It's not just any ordinary crime like murder or homicide or robbery. It's a crime that's sui generis, no? Which is why we have this ATA. Anyhow, so the ATC now going back to one of the powers of the ATC, which is to give an authority in writing to police. I've said that that does not mean that upon designation of a person as a terrorist, he can already be arrested by the police. No, because that designation is under the ATA only for the purpose of application of a freeze order. That's very clear under the ATA. Now, will that designation in writing be also a ground for ATC itself to freeze already the funds of the alleged terrorists?
I believe that would be within the power of the Anti-Money Laundering Council, Your
Yes.
Honor, not the ATC.
In other words, that's a safeguard provided by the law, isn't it?
It could be viewed as such, yes, Your Honor.
Mhm. So we can therefore retain these provisions of the ATE as reasonable enough under the circumstances, and it need not be struck down.
If Your Honor, please, as I understand the arguments, although that is not in our petition, the concerns about the Anti-Terror Council are, number one, that it is an executive body that answers directly to the President. Therefore, it's not an independent body like a court. No due process, no evidence is required before they make a decision on designation or prolonged detention. That is one of our concerns. For example, Your Honor, if let's say the President tomorrow were to announce publicly that so-and-so are terrorists, I believe that the Anti-Terror Council would have no choice but to push through and carry forward that pronouncement of the President, regardless of whether there is evidence or not to support it, because they all answer directly to the President.
Well, that would be speculative, no, Attorney Diokno, because obviously it's just the President saying it and not the ATC actually following up on it. Anyhow, with respect again to the designation by the ATC of a person as a terrorist, can the police immediately conduct a surveillance upon him based on that designation?
Well, based on the provision on surveillance, if Your Honor, please, I believe that would require a court authority. That's not within the issues that our petition is raising, but that is my understanding of the provision.
Yes, but that's one of the issues raised against the law itself.
Co-counsels.
No? Yes, that's one of the issues raised against the law. But again, I think we can safely say that the ATA does provide safeguards with respect to surveillance. It's not an executive function under the ATA, but is a purely judicial function. ATC, or I mean the law enforcement agencies, would have to file with the court an ex parte application to conduct a surveillance, isn't it?
That would appear to
But
be the case.
do they need to get a written authorization from the ATC to conduct, to apply for an ex parte application?
I believe there is a requirement. However, I have not studied that aspect.
Yes, that is required under the ATA. Again, would you say that there is added safeguard towards protecting the welfare of the people against invasion of their privacy by the fact that the law requires that any law enforcement agency, before conducting any surveillance, would have to have first a written authorization from the ATC.
Well, that is an additional requirement.
Yes, it is,
Whether
obviously,
that would be a safeguard is a matter of opinion, I believe, Your Honor. Because if the ATC were to operate as a simple approving authority without discernment, then it would not be a safeguard at all.
So obviously, that's one good provision that is there in the ATA. Authority Diokno.
It would depend. The problem, Your Honor, is whether the ATC would have sufficient standards to make that decision independently of anyone in the executive department.
This feature in the ATA has been there before in the Human Security Act of 2007, isn't
Your
it?
Honor is referring to surveillance? Yes, Your
No,
Honor.
the written authorization.
I'm not aware, Your Honor.
Yes, it's been there. Carry over from the HSA of 2007. And would you know if in the experience of HSA 2007, there has been any written authorization issued by the then ATC?
I'm not aware, Your Honor. Perhaps we could defer to the counsel who is
Yes.
in charge of surveillance.
Well, from what
Attorney
I know, there
Colmenares,
has
Your
been
Honor.
none. There has been none. So there has never been a written authorization to conduct surveillance or anything of that sort in the HSA of 2007. Well, that is all, Attorney Diokno.
Thank you,
Thank
Your
you for
Honor.
your time. Chief, I have no more questions. Thank you.
Now it's already 5:15, and there are still members of the court who would like to ask questions. So we will proceed next Tuesday, February 16. And what will happen next hearing is that the interpellation of the petitioners will be finished. Thereafter, the amicus curiae will be allowed to deliver her, or his rather, I'm sorry, his position, and then we should have sufficient time. Then the respondent will start arguing their position. Then interpellation will thereafter take place. Okay, that's clear now. Lastly, we have seen some lawyers being interviewed in the television stations and even in social media, discussing the merits of this case or these cases, and also discussing the respective positions. No, now we would like to ask the lawyers to please refrain from being interviewed while these cases are pending resolution. You know the effect when one goes into the media and discusses his positions. It might affect the outcome, no, of these cases. So please refrain. We do not like that. We will use our coercive power, no, in disciplining lawyers. I will not mention any more the names. So we're seen in the television stations being interviewed about their respective positions and the merits of the cases. Reminder lang, please, para we will not be affected. Okay? So there being no other matters in today's proceedings session and hearing will proceed next Tuesday, February 16 at 2:30 in the afternoon. We are sorry that we started at 2:30 this afternoon because we ended with our en banc deliberations past 12:30 in the afternoon, and we held our deliberation here in the session room, and we had to fix the room before we could proceed to our today's deliberation. So medyo na-late kami ng konti, but it's not intentional that we should be late. It's because that we ended with our en banc session this morning, 12:30 or almost 1 o'clock this afternoon. So thank you. And there being no other matters, the session is adjourned.